introduce the Commissioner. Ladies and gentlemen, we are about to start with the conference. If I may just kindly ask you to rise so that we can sing the national anthem. Thank you.
Maluka
Thank you. We can all be seated. Ladies and gentlemen, distinguished guests, commissioners, officials, civil society, and all the other community members. My name is Dr. Tina Nzo. I'll be your program director today, and I welcome you to this event. We are brought together here under the theme of looking at the Native Land Act since 110 years old. Today we are faced with a lot of issues related to land tenure, land governance, land ownership. We are looking at issues related to our policy direction when it comes to the expropriation of land, redistribution of land, and also the socio-economic bedrock of land, which forms part and parcel of our development in our country. But then we are faced with the challenge of having to go back into the genealogy of land. And I guess that's why we are brought here today, because of the Land Native Act that was introduced in 1913. But even before then, we also had the Grey Act that was introduced in the late 1800s. So we are going a step back into history, and we also have to reflect of what we have become as a post-apartheid state when it comes to issues related to land that are part and parcel of our socio-economic justice and rights. So on that note, ladies and gentlemen, what I would like to do is to welcome the commissioner who is going to take us through and set us this and actually set the scene of what we are here to discuss today. And this is Advocate Bongani Majola, who is the chairperson of the South African Human Rights Commission, who's actually going to even tell us about the purpose of why we are here, and to even question the idea of whether do we need another conference to talk about this issue, and what kind of outcomes are we expecting from this conference. Advocate Majola, can I ask you to come to the podium? Thank you.
Thank you, Program Director. Ladies and gentlemen, commissioners of the South African Human Rights Commissioners, commissioners of the other Chapter 9 and Chapter 10 institutions, everybody else who is here. I note that there are people who are joining us online. I'd like to welcome you all to this gathering. My name, as you have heard, is Bongani Majola. I'm the chairperson of the South African Human Rights Commission. I've been kindly requested to say a few words to welcome you all to this national conference, a task that I would like to say I am pleased to do. I would like to welcome members of government here and online and elsewhere, members of the judiciary who may be with us in this conference, public servants who either are here with their political principles or have come instead of those principles, or are here even in their personal capacities. Thank you and welcome to members of Chapter 9 institutions, civil society organizations, community-based organizations, academics, individuals with an interest in the topic of the conference, and any members of the media who may be here. On behalf of the Commission, I welcome you again and trust that your attendance will add value to this conference and to the eventual report that will come out of it. The year 2023 marks 110 years since the enactment of the Natives Land Act of 1913. That act prohibited Africans from entering into any agreement or transaction for the purchase, hire, or other acquisition from a person of land from a person other than a native. The act seized the very asset which was central to lives of African people and rendered them destitute. The impact was so profound as it locked black people in servitude, and it closed avenues for livelihood for Africans other than to work for white farmers and industrialists. I appreciate that we are all here because we value the issue of land around which this conference has been organized, but we are all here because of the vestiges of apartheid. The issue of land has been the one which is much difficult to deal with. I would like to underscore this importance. The significance of land in South Africa and the world over can never be overstated, especially in view of the history of black people's dispossession of land by white people. Land is indeed of grave significance to the country and especially to us as the South African Human Rights Commission. In our submission to the Joint Constitutional Review Committee regarding Section 25 of the Constitution, we stated, and I quote, "Land is dignity, yet the majority of South Africans remain landless due to our history of colonialism and apartheid. Colonialism constituted an overwhelmingly violent dispossession and exploitation of land. Slavery and compulsory labor, torture, and ultimately protracted wars of independence," end quote. In respect of this coloniality that our submission spoke of, the Constitutional Court had this to say in the case of Daniels versus Scribante and another. Dispossession of land was central to colonialism and apartheid. It first took place through the barrel of a gun and trickery. This commenced as soon as white settlements began, with the Khoi and the San people being the first victims. This was followed by an array of laws dating from the early days of colonialism. The most infamous of those laws is the Natives Land Act, end quote. It is now etched in our society's imagination that the dispossession of land through the 1913 Natives Land Act was devastating in its impact. One of the Act's most catastrophic provisions for Africans was the prohibition from buying or hiring land in majority of areas in South Africa. In the Scribante judgment, the Constitutional Court made the following observation, quote, "The Natives Land Act apportioned 8% of the land area of South Africa as reserves for the Africans and excluded them from the rest of the country, which was made available to the white majority population. Land available for use by Africans was increased by 5% later, bringing the ownership of bringing the total to 13% of the total area of South Africa, although much of the land remained in the ownership of the state through the South African Development Trust, supposedly held in trust for the African people. Thus, 80% of the population was confined to 13% of the land, while less than 20% owned over 80% of the land. This apportionment of land remained until the end of apartheid and remains virtually unchanged today." End quote. This devastation was captured lucidly by the journalist Sol Plaatje when he stated, "Awaking on Friday morning, June 20, 1913, the South African native found himself not actually a slave, but a pariah in the land of his birth." End quote. He later wrote, "For to crown all our calamities, South Africa has by law ceased to be the home of any of her native children whose skins are dyed with a hue that does not conform to the regulation hue." End quote. This is an important historical context in understanding the issue of land and why we are here for the next 2 days. 29 years into South Africa's democracy, this South African Human Rights Commission says it is high time that the inherent dignity of the people of South Africa be effectively respected, protected, promoted, and fulfilled when it comes to access to land. The Constitution recognizes the devastation caused by the Natives Land Act in Section 25(7) of the Constitution and affirms that a person or community dispossessed of property after 19 June 2013 as a result of past racial discriminatory laws or practices is entitled, to the extent provided by an Act of Parliament, either to restitution of that property or to equitable redress, close quote. The South African Human Rights Commission is also concerned about this devastation. To this effect, we have issued numerous investigative reports, research briefs, and made various submissions to Parliament on the parliamentary bill that affect land. Commissioner J.B. Sibanyoni will speak more about this work of the Commission during plenary 3 later today. For the next 2 days, we are here to primarily reflect on the extent to which the obligation in Section 25(7) has been fulfilled, and how far South Africa has come in addressing the legacy of the Natives Land Act. In the course of that reflection, we hope that a way forward can be carved so that we, as Chapter 9 institutions, can know exactly what our role is in ensuring that this atrocious legacy is addressed. At a secondary level, we would like to form partnerships with all of you and the rest of South Africa so that we can work together in ensuring that the legacy is tackled and obliterated. Lastly, we hope to codify all these deliberations in which we hope will come out a map for where to go from here and how to get there. Some of the foundational themes to this conference, which will inform all the discussions, are the following. 1. What measures have been taken to fulfill diligently and without delay the constitutional obligation in respect of land, especially the obligations in Section 25(7) of the Constitution. 2. What measures have been taken to implement the findings and recommendations in the various reports and research briefs issued by Chapter 9 institutions, NGOs, and other research inquiries. 3. If no measures have been taken, the reason why there has been such inaction. 4. If measures have been taken, what has been the result of those measures? And 5. What can Chapter 9 institutions, civil society organizations, and others do to assist ensuring that the government fulfills its obligations in terms of the Constitution with regard to access to land? These are just some of the thematic issues that we hope will inspire, influence, and shape the discussions that are to take place in this conference. With that said, I wish to open the conference and welcome you all here. The magnitude of the challenge facing the country and the rest of the world calls for a concerted, coordinated, and cooperative national effort in which government in each of its three spheres and a panoply of resources and skills are marshaled, inspired, and led. This is a quote from the Treatment Action Campaign judgment of the Constitutional Court. And this is what the South African Human Rights Commission hopes to achieve through this gathering. I thank you.
Thank you very much, Advocate Majola. Indeed, it's time for us to take stock of whether we are still walking in the right path when it comes to all the recommendations that have been made and the researches that have been made over the years, post-1994. But before I call Commissioner Sibanyoni to come up to the podium, I would like Thomas Mzwendu Masuku to give us a recital of a poem which says, Ukhalelani Gonyane Gandaba. If Thomas is with us, can we have him giving us that recital of that poem? He's not around. Okay, all right. Well, let's move on. Commissioner, can you please take us through in terms of setting the scene? Thanks.
Good morning, everybody. All protocol observed. And Bulise Naba joinile online, as well as people who are streamed on, because this event is streamed. And then program director, I am to recite the poem by Thomas Mzwendu Masuku. And then Thomas Mzwendu Masuku is one of the first African lawyers who were practicing in townships. He was practicing in Atteridgeville, the west of Pretoria. Some of them were practicing in Marabastad. The poem that I'm going to recite or render is in isiZulu. But at the end, for the time that I've been allocated, I will give you the context. I will contextualize this poem. It is the poem that I used to recite when I was at high school at Elukanyisweni in Wheatbank, Emalahleni. I'm wearing the jacket of the South African Human Rights Commission. It's not a blazer. I'm not missing my days when I was still a student. But I want to tell you that this poem is a lament on land dispossession, but it missed the hammer of the powers that be, because had they known what was the context of the poem, it would have been banned, like many books were banned, songs were banned, and the like. Without any waste of time, Thomas Mzwendogo Masoko, the attorney, had a collection of 33 poems, and then I chose poem number 10. The title is Ukhalelani Nkonyane Kandaba. It's a question that we hope that this conference is going to answer in our deliberations, so that at the end we have the answer. Why is Nkonyana Kandaba crying? Why is Mjokwana Kandaba crying or weeping or lamenting? It goes like this. Ukhalelani Nkonyane Kandaba. Ukhalelani Nkonyane Kandaba. Ulilelani ke mbali kaZulu. Ngibona izinyembezi zakho ndaba. Ngibona izizwe zikuhleka usulu. Wawuyisilomo ezinsizweni. Uyisimomondiya esimhlophe. Uyinkanyezi esibhakabhakeni. Ubuso bakho bunjengeqhwa elimhlophe. Namhlanje usunjengenja. Ujuluka imini nobusuku. Unyanyeka okwamathenja. Uyinhlekisa zonke izinsuku. Kwayaphi ukwenama kwakho kwayizolo? Kwayaphi ukusasa kwakho kwakuthange? Konke lokho kwedlula namazolo. Amazolo ezitha nabaphangi. Ngiyazibona izinyembezi zakho zihlaba enhliziyweni okomkhonto. Ngiyakwazi nokuhlupheka kwakho okubuhlungu kwenxeba lomkhonto. Uyasetshenziswa, awuphumuli. Ushaywa ngoqotho, awukhulumi. Ujeziswa ngeze, awububuli. Ukhungwa ngentambo, awushukumi. Untshentsheta uzulu ngenakhaya, wena owangumnikazi wezwe. Ugcweleziwe, awunasibaya. Kwathi wakholwa, wephucwa ilizwe. Namhla ukhala isibibithwane, awunakwe umuntu. Ulila wedwa, uphezu kophondo lukaBhejane. Emhlane wakho imivimbo yodwa. Wonke amadlozi akuflathele, washiya amasiko akini kwaZulu. Namhlanje ntombi, usizi uluthwele, ukhala wedwa, unetha izulu. Lofika nawe elakho kusasa, wophuza amasi, uyeka umlaza, wodla umcaba nomthubi, wosasa, uyokwenama, ukholwe ngamakhaza. So inqamula insimbi yobugqili, abaphangi boya kwagoqanyawo. So wagqiba siwaqeda amaqili, so wanqoba ngezikhali zawo. Thula, yesula izinyembezi zakho. Vula ikhanda nenhliziyo yakho. Inkululeko isezandleni zakho. Impumelelo isemandleni akho. Ukhalelani Nkonyane Kandaba. Vuka, sebenza, phaphama, kusile. Zivuke zonke izizwe zomhlaba. Vuka, vunula ilanga liphumile. In contextualizing this poem, ladies and gentlemen, the poet here, when you listen to it, you will think that he is talking about a beautiful lady, or when he says isimomondiya, because he says uyinkanyezi esibhakabhakeni, you are a star in the heaven. And he says ubuso bakho bunjengeqhwa elimhlophe. And then he says your face is as bright as snow. And then the poet continues to say, today you are being despised like a dog. You are being forced to work. You don't complain. And then it says, I can see your tears running down. He says, I know your pain is like a pain of a spear. And then the title of the book also is saying, Izikali Zembongi, the weapons of the poet. And then he says, today you are like a person who is always weeping, and then your ancestors have also forgotten you. You were requested to follow the religion, and you were dispossessed of land. And then he says, but one day, your day will come where you will rejoice, where you will be excited. Now, in this stanza where he has got all these cliques, the poet, in my view, is trying to also think about the koi and the sen, because those are the people where we had the cliques. When he says, so wangamula, so ingamula insimbi yobugqili, abaphangi boya kwagoqanyawo, so wagqiba siwaqeda amaqili, so wanqoba ngezikhali zawo, will defeat them with their own weapons. What are their own weapons? Is the Native Land Act. Therefore, we will also use the legislation, the act, to get back the land. At the end it says, when it says Tula and wipe your tears, and again he repeats and ending by saying, why are you crying? Why are you weeping? Nkonyane kandaba, njogane kandaba. I end here and saying, conference, let us answer, why is Nkonyane kandaba weeping? Why is Mjogana kandaba weeping? Thank you very much.
Commissioner, thank you so much for that very powerful poem and message. It really makes us to think, especially if we have a memorialization that is embedded in poetry, that really tells us so much about the history when it comes to land dispossession in this country. It's a very powerful poem. Thank you so much. Ladies and gentlemen, we are about to now move into a plenary session where we will have 4 speakers who will actually take us through a conversation about unpacking Section 25 of the Constitution. And this panel will be moderated by Commissioner Philile Nduli. I hope she is here with us. But before we move into that panel, I would also like to relay the message that we do have free Wi-Fi that is available. And the name of the Wi-Fi is called Birchwood Guest. And you do not need to put in any password, so you'll just go straight into the Wi-Fi. So as we prepare to get our panelists, I will call out their names and they will join us up on the stage. The first name is Ms. Chanel van der Berg. She is with the Office of the United Nations High Commissioner for Human Rights. Thank you very much. Ms. Mpho Rabuone, she comes from Ndifuna Ukwazi, and that is a civil society organization. And then we have Ms. Nolundi Luwaya. She is with the Land and Accountability Research Center. You're also welcome to join us. We also have Ms. Cameron Lowe, who is with the Women on Farms project. Please join us for the conversation. And here they'll be talking about various themes under Section 25 in terms of what can we learn in South Africa, What are some of the struggles that are led by socio-political activism in South Africa? And also, what do Chapter 9 bodies and other institutions create in terms of advancing our constitutional democracy? As our chairperson, Ms. Philile Ntuli. Oh, she's online. Okay, lovely, excellent. Thank you so much. Let me hand over to you, Commissioner, so that you can take over the program. Thanks.
Thank you very much, Dr. Nzo. Are you able to hear me? Good morning. Are you able to hear me?
Yes, we are. Good morning. Yes, ma'am.
Can I get an indication if you are
yes,
able
we
to
can.
hear?
We can hear you,
We
Billy.
can hear you.
Thank you very much. Good morning, Program Director, members of the National Executive who are with us, both physically as well as virtually, members of Parliament who are also joining us physically and or virtually, commissioners of Chapter 9 institutions, members of academic institutions who are with us, members of civil society, and all other protocol observed. Welcome, ladies and gentlemen, and thank you very much for joining us at this very, very important conference that we have coordinated as the South African Human Rights Commission. I must first just apologize for not being able to be with you physically. As of last night, I was scheduled to travel, but due to emergency, I had to then cancel my travel. But I am hoping to be with you virtually throughout all of the proceedings of the conference. Ladies and gentlemen, the role of civil society in building and strengthening our democracy cannot be overstated. As a Chapter 9 institution, in particular, the South African Human Rights Commission, we are tasked by the Constitution to act independently, without fear and without bias. And in pursuit of this task, we view civil society as a critical and important role player and pillar. The first and most basic role of civil society is to limit and control the power of the state. And of course, in any democracy, there is a need of a well-functioning and authoritative state. But when a country is emerging from decades of authoritarianism and dictatorship, as ours is, it also needs to find ways to check and to monitor and to restrain the power of political leaders and state officials. And this is the important role that civil society is able to play in consolidating and strengthening democracy. Civil society actors should, however, watch how state officials use their powers. They should raise public concern about any abuse of power as well, and they should lobby for access to information, including freedom of information, freedom of the law, and rules and institutions to control corruption. Another key important function of civil society is to expose corruption and corrupt conduct of public officials and to lobby for good governance and reforms. Even where anti-corruption laws and bodies such as the South African Human Rights Commission do exist, we cannot function effectively without the active support and participation of civil society. Ladies and gentlemen, this is the reason we as the South African Human Rights Commission have seen it fit to begin our conference with this plenary encompassing of civil society, noting the very important role they play in the discourse around accountability at a national level when it comes to the consolidation of democracy. We are therefore very pleased to welcome our panelists this morning. As named and mentioned by the program director, we welcome you, Ms. Chanel van der Berg, Ms. Mpho Raubane, Ms. Nolundi Luaya, as well as yourself, Ms. Kamalo McKay from Women on Farms Project. We hope that by the end of this panel discussion, we will leave the session with a very clear understanding of the imperatives of Section 25 and how it has been interpreted and understood since its promulgation. I will then offer about 10 minutes to each of the panelists to offer us their own reflections on the questions that have been put to them, and thereafter we can begin to have a discussion and open it up to the room to also pose questions so that we can reach our aim towards the end of the discussion. I therefore will start with yourself, Ms. Chanel van der Berg. Welcome. Please do offer us your reflections as invited. Thank you so much.
All right, I have a PowerPoint. Thank you. All right, good morning, everyone, and thank you to the South African Human Rights Commission for giving the opportunity to the Office of the United Nations High Commissioner for Human Rights to be part of this important conversation. As we all know, Section 39 of the South African Constitution compels a court, tribunal, or forum interpreting the Bill of Rights to consider international law. So today I will unpack with us all the international law implications and recognition of land, especially in terms of human rights. All right. So at international law, there is a recognition that land is a prerequisite for various human rights, including the right to a clean, healthy, and sustainable environment, which was recognized as a fundamental right of everyone everywhere last year by the General Assembly. The right to an adequate standard of living, which includes the right to housing, the right to food, the right to clean water and sanitation, and of course then the right to development. All human rights are universal, indivisible, interdependent, and interrelated. So when we think of land and how land supports economic, social, and cultural rights, we also cannot forget about the significance of civil and political rights. All rights are relevant when we speak about the issue of land. In the context of land, civil and political rights are often at risk for human rights defenders defending rights in land. And this is perhaps the most direct implication of civil and political rights in this context. So looking at some of the international law sources pertaining to land, we have the International Covenant on Economic, Social, and Cultural Rights, which is perhaps most directly applicable to the issue of land. South Africa ratified the International Covenant on Economic, Social, and Cultural Rights in 2015. And the South African Human Rights Commission also engaged very closely with the Committee on Economic, Social, and Cultural Rights in 2018 during the first constructive review of South Africa under the Covenant. The Convention on the Elimination of All Forms of Discrimination Against Women is also of relevance in that Article 14 looks at particularly at the plight of rural women and their relationship to land. And then the International Covenant on Civil and Political Rights will be of a special importance where human rights defenders' lives and safety are at stake. In addition to the primary human rights conventions, which also includes others, there are also various soft law sources, the first being the Universal Declaration of Human Rights, which is celebrating its 75th anniversary this year. So it's a very important moment for all of us all across the world to reinvigorate the importance of human rights and start seeing human rights as positive tools for change that can really affect change and transformation in our societies. Article 17 of the Universal Declaration recognizes the right to property and also guarantees that no one will be arbitrarily deprived of property. Dignity is central to the Universal Declaration, and Article 25 of the Declaration also recognizes the right to an adequate standard of living, which has all these various components of food, water, housing, and so forth. Then in 2007, the General Assembly adopted the United Nations Declaration on the Rights of Indigenous Peoples, which South Africa endorsed. And in 2018, there was the United Nations Declaration on the Rights of Peasants and Other People Working in Rural Areas. South Africa was actually one of the co-sponsors of this declaration. Then we also have recommendations, guidance, and jurisprudence emanating from the Committee on Economic, Social, Cultural Rights. And last year in 2022, they issued a general comment, number 26, on land and economic, social, and cultural rights. In this general comment, they also refer to the Food and Agricultural Organization's voluntary guidelines to support the progressive realization of the right to adequate food in the context of national food security. And these voluntary guidelines recognize many of the elements that we see in Section 25 of the South African Constitution, including restitution and redistribution. So it might be worthwhile to also have a look at these soft law sources. Now, in terms of international law, the state parties have various obligations. The first being equality and non-discrimination. So when we speak about realizing the human rights that underlie and depend on land, land distribution and restitution processes cannot discriminate. And this would include on the basis of race, ethnicity, gender, and of course disability status as well. This is an extremely important duty on all member states that must be observed in all policy development as well as implementation. Then we also have the duty to ensure that there's meaningful participation, consultation, and transparency in any land reform initiatives. So this would again include the development of laws and policies, but also their implementation. Then, of course, as with all human rights, we have the obligation to respect. In the land context, this will also imply a duty to prevent, but also to abstain from forcible evictions in the context of land. We also, as with all human rights, have the duty to protect. And in the land context, this would include setting clear standards for non-state actors such as business enterprises who might want to conduct activities on the land, including extractive industries, as well as, of course, large-scale development projects. And then, perhaps the most importantly, is the obligation to fulfill. So the state is under an obligation to facilitate secure, equitable and sustainable access to, use of, and control over land for those who depend on land to realize their economic, social, and importantly, cultural rights. The state is under an obligation to recognize the social, cultural, spiritual, economic, environmental, and political value of land, of communities with customary tenure system. Then there is also a specific duty to look at agrarian reform in terms of Article 11.2 of the International Covenant on Economic, Social, and Cultural Rights. And agrarian reform is set as an imperative to combat hunger and to help eradicate poverty, which is often closely linked, as we have heard already, to the dispossession of land. And then, very significantly, the state is under a duty to use the maximum available resources at its disposal to progressively realize all the rights enshrined in the International Covenant related to accessing productive resources, and particularly with regards to this right that we see in the ICESC to an adequate standard of living and everything that's needed to have an adequate standard of living. So a life lived of dignity on a basis of equality with everyone else. Of course, in discharging these obligations, there are certain issues that require particular attention, and as we have already heard, corruption is one of them. In order to help combat corruption, it is necessary that consultation and participation are meaningfully engaged in, and that there is a respect for the rule of law at all points of policy development and implementation. The human rights principles of transparency and accountability are especially important here. At international law, there is a recognition that when we talk about expropriation for a public purpose or in the public interest, there is room for corruption, and therefore we need to build accountability mechanisms to ensure that corruption is eliminated and prevented at all levels of land distribution and restitution processes. Then in South Africa, we are all too familiar with the tenuous position of environmental human rights defenders. Often human rights defenders working in the land context are working for the environmental function of land and face severe risks to their lives and safety. This is especially so in the context of extractive and development projects. And we have witnessed it here in South Africa, but unfortunately this is a regional and a global trend as well. So human rights defenders then should be also always in our minds as we develop and implement policy. And then of course, climate change being one of the most significant crises facing humanity. So it's important that mitigation policy should lead to the absolute emission reductions through the phasing out of fossil fuels. There are times where policy mitigation efforts can actually come into conflict with rights related to land. For example, when it is attempted through reforestation, large reforestation projects, when really we should be looking at eliminating the use of fossil fuels. And again, there is an obligation on all state parties to use the maximum available resources available to them to mitigate the effects of climate change. And this is of significance to land, of course, because we see that through climate change, a lot of land is also using its value for the communities who depend on this land. There are also specific groups that require particular attention, and this is also recognized at international law. In sustainable development circles, we would say that these groups are at risk of being left furthest behind in South Africa's land reform efforts. The first are women. So women face intersectional discrimination. So of course in South Africa, a black woman in a rural area will face using and controlling land than other women or men might do. Measures need to be adopted to ensure that access to use and control of land is available to women on an equal basis as men. And this will also require that land regulations and structures that discriminate against women are removed. Indigenous peoples also merit specific attention and special measures in the context of land and human rights. Indeed, it's the African Commission on Human and People's Rights that has recognized that indigenous people who have unwillingly lost possession of their lands without their free and prior consent after a lawful transfer to a third party are entitled to restitution thereof or to obtain other lands of equal extension and quality. And then a third group that merits special attention are peasants and other people working in rural areas. And here we can think of farm workers, and looking forward to also hearing that perspective on this panel today. We think of farm workers, but also communities who depend on the commons and communal land for sustenance, for cultural reasons, and so forth. So when we start thinking about reimagining Section 25 in the way we interpret it, in the way we apply it, or the way we conceive it, it's important to keep these groups of persons in the front of our policy development minds, and at the same time be wary of the issues that have been raised internationally, so that we can avoid them and ensure that land reform is effective in South Africa. Many of the United Nations human rights mechanisms have made recommendations and observations pertaining to land for South Africa specifically. So most recently in 2022, South Africa underwent the Universal Periodic Review. And there were several recommendations pertaining to land that were supported by the South African state. So for example, the state of Palestine recommended to implement the land redistribution and restitution program. And we can see there the position of South Africa is that this recommendation is supported. Likewise, the recommendation by New Zealand to continue to address the challenges of food insecurity, rights to resources, landlessness, that disproportionately affect indigenous Khoisan communities was supported. There are several other recommendations from other countries in this peer review mechanism that were likewise supported by the state of South Africa. This signals political will to implement these recommendations when they are supported, because they were not simply noted, or in other words, rejected. The Universal Periodic Review recommendations can therefore be a powerful advocacy tool as we try to fight for rights to land and related human rights. Treaty bodies have also made recommendations. So when South Africa ratifies a treaty, there are these treaty bodies of experts who monitor implementation of these human rights treaties for all countries who have ratified them. So the Committee on the Elimination of Discrimination Against Women in 2021 recommended to South Africa to ensure that legislation and policies on land reform and land use fully recognize and protect the right of rural women to land use and ownership. It also noted that there is a need to ensure access for rural women to basic services, including, as we have said, the rights to housing, to clean water and sanitation, electricity, as well as to economic opportunities and technological progress related to land. So if women are able to access land and control land, it will also open up other economic resources for them, such as credit. This is thus very important. And of course, data is a perennial issue. Without data showing us how we are progressing in terms of the realization of rights, we cannot address gaps, whether they be policy or implementation gaps. So there is a need for data disaggregated according to all these grounds, and for disaggregation to reveal intersectional forms of discrimination, such as the barriers faced by a Black rural woman. The Committee on Economic, Social and Cultural Rights in 2018 also made recommendations to South Africa pertaining to land, noting that despite South Africa's efforts to effect land reform, their targets are well below being met, and that there is also poor post-settlement support and lack of training for many beneficiaries of land reform. The recommendation is thus to accelerate the implementation of land redistribution and restitution, and to ensure that adequate support is provided following redistribution or restitution. And this is also a very important point. We can redistribute or effectively implement land restitution, but we need to provide that support so that value can still be derived from land, and the rights that land support can still be realized. The Committee on the Rights of the Child in 2016 also recognized especially the plight of Indigenous and Khoisan children who are facing hunger and extreme poverty due to the dispossession of land. And therefore, the Committee on the Rights of the Child suggested or recommended legally recognizing the rights of Indigenous peoples, including Khoisan peoples, and also developing a national action plan to respect, protect, and promote the right of Indigenous children, and to eliminate their food security, poverty, vulnerability, violence, and exploitation with their full and effective participation. So when we think again about the principles and obligations of the state, equality, non-discrimination, participation, we can see that they all need to be present at all stages of land reform efforts. The Committee on the Elimination of Racial Discrimination has also made a recommendation pertaining to land, again concerned about the situation of Indigenous people who continue to suffer from extreme poverty and marginalization and face discrimination and difficulty with language, education, and land redistribution, and who lack information about their rights under the Convention. The committee also expressed some concerns about the Traditional and Khoisan Leadership Bill, questioning whether it is in line with the approach of Indigenous peoples to leadership. And last, the Human Rights Committee, which monitors the implementation of the International Covenant on Civil and Political Rights, has also acknowledged that government has submitted to it that it is working on a policy and legislation to look at exceptions to the 1913 cut-off date, but that nevertheless progress is too slow in terms of land restitution and redistribution. The committee accordingly recommended that South Africa steps up efforts to ensure the processing of land restitution claims lodged under the Restitution of Land Rights Act. So what are possible next steps and possible remedies at international law? We know that in terms of the South African Constitution, there is a duty. Courts, tribunals, forums must consider international law when interpreting the Bill of Rights, including Section 25. But is there anything that can be done in the international sphere? One next step that could provide redress for those dispossessed of land who are still dispossessed of land today and who face intersectional forms of disadvantage and discrimination is to lobby for South Africa to ratify the optional protocol to the International Covenant on Economic, Social and Cultural Rights. The optional protocol to the ICESC provides for an individual complaints mechanism, which means that all of us in South Africa as rights holders, including the rights pertaining to land, would be able to approach the committee if we feel that our rights have been violated. However, this optional protocol needs to be ratified. If one reads the optional protocol, one will also see that it is taken directly from South African constitutional court jurisprudence, some of the provisions. So South Africa has really been a major role player in creating this jurisprudence, which has been integrated by the international human rights system. Another possible step for redress is to utilize the special procedures of the Human Rights Council. Now, the special procedures can be working groups, independent experts, and special rapporteurs, and can be both thematic mandate holders or country-specific mandate holders. The special rapporteur for health, for example, is South African, and these are normative mandate holders, and they are independent human rights experts. So they are not employed by the United Nations and discharge their mandates in this manner. There are various thematic mandate holders who are of relevance to the issue of land in South Africa, including the Special Rapporteur on the Right to Food, the Special Rapporteur on the Rights of Indigenous Peoples, the Special Rapporteur on Extreme Poverty and Human Rights. But also there are Special Rapporteurs on the environment. There is a new Special Rapporteur on climate change and human rights. There is a Special Rapporteur on clean water and sanitation. So these special rapporteurs undertake country visits at the invitation of member states. They act on individual cases of reported violations and concerns of a broader nature by issuing communications to states and others. And they contribute to the development of international human rights standards, which, as we come together to think about Section 25, what it means in today's South Africa, special rapporteurs might also be able to provide normative guidance in that respect. And then they engage in advocacy, raise public awareness, and provide advice for technical cooperation. I've provided the website there, so please have a look at the mandate of the special procedures, and if there is a need for further guidance and technical support on how to engage with the special procedures, the Office of the High Commissioner for Human Rights Regional Office for Southern Africa, based here in Pretoria, would be glad to assist. All right. And then in conclusion, just as we all, as the world, celebrate the 75th anniversary of the Universal Declaration of Human Rights, let us work together to use human rights as tools for positive, fundamental change and transformation. Thank you very much.
Good morning, everyone. My name is Mpora Weane. I am from Difunowazi, an organization based in Cape Town. I've been asked by the Commission just to share my thoughts around Section 25 and the realization of this constitutional obligation. I want to start with a historical context. It's true that we're commemorating 110 years after the passing of the 1913 Land Act, and the poor and working class, who remain overwhelmingly black, remain transient features of our city's landscapes. We can't forget that forced removal and legislated land theft are the basis of our apartheid spatial geography today. But 1994 bore some promise of change, as the issues at the heart of the land debate became about the reversal of this dispossession and how large-scale redistribution of land could contribute to transformation of the economy and the reduction of poverty, both in the rural and urban contexts. This is the promise of Section 25 of the Constitution. But unfortunately, these questions of reversal, redistribution, haven't developed substantially beyond rhetoric and political machinations. Yes, the acknowledgement of the slow pace of land reform is plentiful, but the concomitant action around addressing this is not forthcoming. The President himself acknowledges that the continual monopolization of a key means of production like land is not only an obstacle to a more egalitarian society, but has the potential of being a recipe for social unrest. He is well aware that the hunger for land is growing, and this is especially true, yes, amongst the urban poor. But what is telling about these discussions and debates around land reform is the lack of the mention of urban land reform. In a recent report, the South African Cities Network found that the urban land debate was one of the most neglected but most influential issues in post-apartheid South Africa. So if it's one of the most influential issues, then why is no one talking about urban land reform? And why is everybody mum around the question of urban land redistribution? We cannot deny the rapidly increasing rate of urbanization in our country, with 67.85% of the population being urban-based in 2021. And with the majority of our people in urban areas, surely this warrants some concerted intervention around the urban land reform question. But it may be that this intervention has been hamstrung by the transposing of concepts and discussions, debates around rural land reform. We must recognize that any point of departure must acknowledge that our interaction with urban land comes with a historical and layered intersection between state and the market. Oh, she'll forgive me for my pronunciation, but Hashemaya et al. Says that the South African land reform debate is burdened by high levels of wealth inequality, with at least half of South Africa's wealth estimated to be owned by 1% of South Africans. The 90 to 95% is owned by the wealthiest 10%. And this is compounded by the fact that a vast majority of this wealth is vested in urban real estate. And that ties the fate of urban land directly to the functioning of an important part of our economy. So I suspect that the reason that no one is talking sufficiently about urban land reform is because of the explosive potential such transformation has to effectively upend our economy as we know it. Our experience in advancing urban land justice as Ndifunukwazi is that of an activist organization which utilizes law and community organizing to promote the realization of constitutional rights, social justice, and representation for the poor and working class. We work to advance urban land justice in Cape Town through the pursuit of the expansion of equitable access to justice, equitable access to land, affordable housing, supporting tenants' rights, and securing tenure in both private and public housing towards building a more just and inclusive city. Now, in utilizing these various tools to advocate for a tangible realization of Section 25(5) in particular, our experience has been a combination of a permissive legislative framework that stops just short of imposing positive obligations, a lack of political will and a lack of societal reimagination, and the entrenched financial interests that unduly influence decision-making when it comes to questions of land and land use. Now, all of these factors come together to result in the replication of apartheid spatial geography and spatial injustice. So looking at the legislative front, Section 25(5) makes it clear that the state must take reasonable measures in fulfillment of the obligation under the section. But despite this, there remains a legislative lacuna, as there's no targeted framework to give effect to guide, and to direct land redistribution as a constitutionally mandated land reform program. The existing legislation includes the provision of the Land Assistance Act of 1993, or the PLAA, the Spatial Planning and Land Use Management Act of 2013, the Government Immovable Asset Management Act of 2007, and the Municipal Finance Management Act of 2003. This existing legislation is of limited application and, as I said, falls short of the imperatives set out in 25(5). In 2019, we were invited to give input to the reference group on state land and land reform and redistribution, which was convened in response to the Presidential Advisory Panel on Land Reform, Agriculture report. There we pointed out that the legislative deficiencies were rife. We specifically noted that the high-level panel as well noted that the PLAA was insufficient in that it failed to define equitable access in a meaningful way. It also wasn't a suitable vehicle to carry out the objectives of Section 25(5). Similarly, with SPLUMA, while it makes positive inroads and advances in aligning spatial planning, land use management, and development with the obligations set out under Section 25(5), it too fails to articulate how objectives of redress and redressing the imbalances of the past could actually be actioned. The same could be said about GIAMA. GIAMA provides a uniform framework for immovable assets held by national and provincial government. Its principles of asset management includes the prioritization of the provision of basic services instead of prioritizing profit in the disposal of a immovable asset. It emphasizes that in requiring best value for money, this value also includes a social aspect. But still, what is absent is a obligation compelling the state to proactively release and give of the land so that people may be able to finally realize the imperative set out in 25.5, that being of equitable access. Another shortcoming with legislation such as GIAMA is that these provisions, although progressive, are primarily based on discretionary actions of state actors. Now, where this discretion is exercised, there's limited scope for affected persons or communities to challenge these decisions, specifically where there are also limited avenues in terms of the legislative frameworks available for these challenges to be heard in court. Now, these challenges are necessary because such principles are discretionary and left largely to interpretation. And a live example of where these principles have given promise and scope for positive development, but the lack of political will by the administration of the time has hampered this promise, is with our Tafelberg matter. This case involves a situation where a prime piece of Sea Point real estate was disposed of by the provincial government, despite the fact that there is a dire need for social and affordable housing in such contexts. What then resulted was the culmination of a campaign that later grew into a social movement that now calls itself Reclaim the City. This social movement was based on the foundation that people wanted to realize land for themselves, for their benefit, so that they may be able to live where they work, where they provide value, and that they may have access to amenities and resources. But instead, what the province had done was not considered the dire need for housing in Cape Town. Instead, they valued profit over people's lives and people's advancement. Now, despite such limitations, we continue to agitate for a reimagined society. We challenge the state and other actors to reimagine the city. And we want to create a city where it is not defined by inequality or skewed patterns of land ownership, but it is defined by accessible, inclusive cities that espouse this principle or concept called the right to the city. We draw inspiration from other jurisdictions, such as Brazil, where their 1988 constitution provides for a social conception of the function of land. Such legislative progressions in their context led to the enactment of the city statute, which required city management and city decision makers to first consider the social function of any vacant or underutilized land, and equally prohibited any level of speculation and profit-building holding of land. Although we do not have similar enabling legislative frameworks in our context, we hope that in our work, in our advocacy, we will begin to create avenues for such legislation to be considered and created and finally passed. We are in the midst of a profound land and housing crisis. Today, there is more visible homelessness than at any other point in our democracy. There's also far more informal settlements, growing from 300 in 1994 to over 3,000 this year. Hundreds of thousands, if not millions, of South Africans live with no real tenure security. Following the constitutional amendment debate around Section 25, the ruling party has significantly pivoted towards relying on state land as a large part of their land reform program. But still, in the meantime, we sit with a government that owns hundreds of thousands of hectares of vacant and underutilized land, sitting idle, that could be used to meaningfully address our crisis. Given the intensity and extent of this issue, don't you think it is high time that the government provides land directly to those who need it? So along with our social movement partners, Ndifunugwazi is offering the government a clear solution that could considerably ease our tenure security and housing crises. The land and housing situation in South Africa continues to get worse each year, and it is time to take action to implement solutions that are actually well within reach. What is such a solution? Well, we are saying that providing donations of land through the State Land Disposal Act is perhaps the fastest and quickest route to building homes and neighborhoods that genuinely serve the interests of their residents and the wider community at large. Where the state won't enact pointed, direct legislation that will finally trigger land redistribution, specifically in the urban context, we have opted to rely on apartheid-era laws, and we use these laws to request the president and his ministers to give people security of tenure through the provision of land, direct control of the land through our slogan, the land in people's hands. We hope that through this initiative, the president will act to finally fulfill the objectives of land reform and redistribution. Now, what is the role of the Commission in this context? We would call on the Commission to support communities across the country making this call for donations. While the Human Rights Commission's general mandate is the protection of all human rights, it has a special mandate or role for the protection and realization of socio-economic rights. This special mandate is rooted in the importance attached to addressing the socio-economic disadvantages suffered by the majority of South Africans in this country. And further, we note that the Commission is provided the power under Section 13(2)(a) of the South African Commission Act to request any legislature, including Parliament, and recommend to them that they adopt or create legislation that will promote the culture and respect of human rights. We then call on the Commission to pressure the Parliament and the provincial legislatures to enact legislation that will address the legislative lacuna that we have been speaking to. What I find ironic about such gatherings in relation to people's realities is the fact that we are reliving the past, but not remembering. Yes, we commemorate these instances, but we still do not remember. In seeking spatial justice, we must undertake steps to rectify the deep severances that have been created between ourselves and the land. We need to remember and recreate those bonds between ourselves and the land as extensions of the land. It is only in that way that we will be able to remember, as in put ourselves back together, and will no longer be transient features of our city's landscapes. In Cape Town, for instance, we are battling a series of municipal bylaws that effectively are promulgated dispossession. These bylaws have resurrected apartheid era intent in as far as dispossession and displacement is concerned. These bylaws target the poor, although being legislatively neutral, and these bylaws act to displace people in the sense that poor people no longer have a sense of belonging in the city of Cape Town. These measures resurrected these attitudes and are reminiscent of the 19th and early 20th century laws of dispossession. Now, while these laws are recognized as being instrumental in legitimizing land theft of the past, why is it that we still have old legislation such as the last will and testament of Cecil John Rhodes on our statute books? We find ourselves in a moment where we are not only fighting to realize the positive rights, such as land reform and redistribution, but we are actively guarding against the erosion of the constitutional entitlements and protections that the descendants of the dispossessed have been given through the Constitution. We are fighting a war on two fronts. I was on radio the other day speaking about issues of tenure insecurity, food insecurity, and the like. And the host summarized it quite aptly by saying all of these issues that we tend to compartmentalize quite neatly as civil society and the state.
Ms. Rabona?
Yes.
Ms. Rabona, just a reminder of time, please.
All right, I'm finishing up, thank you. All of these things that we compartmentalize and address in a siloed nature as civil society and the state actually speak to one central theme of belonging. We need to ensure that equitable access is realized not as an empty constitutional imperative, but as a means for our nation to heal. Our access to land is informed or will inform a new collective memory, which has up till now been centered on structural violence and lack. But for us to shake this off and for us to realize our birthright, we must resolutely facilitate this equitable aspect of this right. This right guarantees us access to abundance, this abundance being our land. We call on the state, on the commission, and all civil society actors to rally behind this call around the disposal or donation of state land directly into the hands of the people.
Thank you very much, Ms. Rabone. And also thank you, Dr. Van der Berg, for your presentation earlier as well. We had a few technical difficulties, but the IT department has assisted us. I remember being in a conference once, and the facilitator noted when the speakers were going beyond their allocated time to note that time can also be a human right and the time of others as well. Colleagues, just a kind reminder that we are allocating 10 minutes per speaker, and the time that we take outside of that allocation is time we take from other speakers. So we are allocated up until 11:15 to the session, and we had also allocated time for a discussion. We are obviously way beyond that allocated time, but we do hope to make it up as we go along. Ms. Nulundu, Nolundi Luaya, please welcome to the podium, and we look forward to also hearing your reflections on the topic at hand. Over to you, Ms. Luaya.
Thank you very much, Chair. Molweni, and my greetings to you all. My thanks to the conference organizers for the opportunity to speak to you. I have a very brief slide input that I wanted to start with. I thought it might be helpful, colleagues, to start with a graphic representation of what it is that we're discussing namhlanje. We are gathered in this conference under the shadow of recognizing that it has been 110 years since the passing of the 1913 Land Act. The image that you're seeing on the screen is a graphic representation of the 7% of South African land that was set aside for natives. So the dark shaded areas are the only areas in which black South Africans were afforded access to land. The remaining white areas reflect the 87%, but at this point it would have been more than that. It would have been 93% that was set aside for white South Africans. The following image then is what brings us to the 13% that we know so well. The pink and green together make up 13%. So the pink is the original 7, and the green is the additional additional allocations of land that was set aside through the 1936 Act, which brings the total area that was set aside for black South Africans to 13%. And we must remember that the 1913 Land Act worked together with the 1936 Land Act to present this picture. I then wanted to use this particular image, again something we know well in the legacy and history of our country. This is a graphic representation of the homelands. You'll notice that it overlaps, of course, identically with the 13% of land that was set aside for black South Africans. And we know that this was a vicious instrument of the apartheid state to effectively deny black South Africans citizenship within the greater South Africa, requiring that each tribe be assigned a homeland and all black South Africans affiliate with said particular homelands and be denied citizenship to white South Africa. This then is an image that represents the forced removals. Again, colleagues, I seek to highlight here the violent, absolutely legally sanctioned process that was used to create the legacy that we're dealing with today. It was sanctioned by law, it was defined in law, the law made it possible. And so as we discuss legal instruments today that seek to undo this legacy, we have to be mindful of the limits of law as a tool and as an instrument, but also, of course, the fact that we are inheriting laws that actively made this particular legacy possible. And so I would ask us to challenge ourselves to engage cautiously with legal instruments. The final image then, colleagues, the second to final, sorry, is one that overlays the traditional councils as they were in 2010, again against those same boundaries that were created through the 1913 and 36 Land Acts. And again, what I'm seeking to highlight here is something I think that again is familiar to many of us, but the overlap between communities that are abiding by customary law and customary ways of life being overlapped with those same communities that were the absolute victims of severe dispossession and constructed divisions based on this idea of homogeneous, neat tribes for black people and the creation of an artificial black identity. And so what I'm trying to pull through here, colleagues, is the way in which our history still informs our current and potentially informs our future. And then the final image, again, tells a story I think that is familiar to all of us. It's an image that overlays measures of poverty along those same geographical boundaries. The darker the blue, the poorer the area. The lighter the yellow, the wealthier the area. These images are somewhat dated, but I would be confident in asserting that they still reflect an accurate picture. And you'll see in the image that's on your right-hand side, the overlap with, again, the boundaries of the homeland areas and the former native reserves, giving us a graphic representation of what we know, that these areas that were dispossessed overlap with the areas that are the major areas of poverty in our current framework. Thank you. You can remove the slides. Colleagues, I seek, I wish I was going to be that quick. I seek to make, but I have heeded the warning that was offered by our chair. Colleagues, I seek to build on that basis and make 3 points that I would offer to this gathering. I would hope that they would be tangible, workable points for consideration as the collective, but also as the Human Rights Commission considers what it is that Chapter 9 institutions can do to begin to really move the needle forward when we're thinking about land reform in the South African context. My first point is really a plea. It's a plea to Chapter 9, it's a plea to the Human Rights Commission to continue to be vehement advocates for those who have suffered the dispossession that was reflected in those graphic images. It is necessary more than ever that the Human Rights Commission, the Chapter 9 institutions, and other bodies who are tasked with safeguarding the Constitution must ensure that the voices of rural poor, urban poor, people who are dispossessed, and farm workers continue to be at the table. And this plea comes from having observed over the past number of years the ways in which laws are being created, laws are being drafted without particular and significant input from the people whose lives would seek to govern. And so it really is to urge the Chapter 9 institutions, the Human Rights in particular, Human Rights Commission in particular, to not tire, to not give up the fight, but rather to hold steady and to continue to push for the voices of people to be part of the conversation and for people to be able to speak for themselves. And the concrete way in which I would suggest that this is possible would be when we look at the reports of the high-level panel and the presidential advisory panel. Both of those reports make significant recommendations about the ways in which we can make changes to our approach to land reform in a way that would advance the cause forward. I'm picking one, there are many, but I'm picking one. And that would be to urge this collective and the Human Rights Commission to consider putting their weight behind the recommendation made in both panel reports around making permanent a law called IPILRA, the Interim Protection of Informal Land Rights Act. Colleagues, it is the only law that stands between the people who live in the areas that were reflected on those maps and rampant dispossession. I'm going to say that again. It is the only law that stands between the communities who live in those areas that were reflected on the maps and dispossession. What do I mean? IPILRA is an interim law, as the name suggests, which of course should be something that shocks us and worries us, given how far into the democratic system we are at this point. It is a law that recognizes customary land rights and that provides particular protection by requiring that before people are deprived of their land rights, they must give their consent. It remains an interim law. It was designed to hold the gap until a more permanent and more full law was passed. That law was attempted through the Communal Land Tenure Bill, Communal Land Rights Act, in 2010. It was struck down by the Constitutional Court, and we're now in 2023 without a permanent replacement. The recommendations of the panel are that we work on making IPILRA a permanent law and that we seek to bolster IPILRA by drafting regulations that would give the law, which is currently a mere 2 pages, would give it fuller scope and provide it to be a more robust instrument. It is a very clear, tangible and concrete way in which we can actually take all of the work that has gone into the various panel reports, concretize it, and make it have a direct impact on the land rights of people who live in customary areas. That would be my first pitch. My second pitch is one that I've been grappling with for a while, and so I present it here tentatively, but in the interests perhaps of like minds finding a way forward, I'm going to put it to this gathering. It's that the Chapter 9 institutions, I think, can play a leading role in helping us as a nation and as various actors understand the flaws in how we have approached land reform. What do I mean by that? What I mean is that our land reform program has relied heavily on legal instruments. Restitution is enforced through an act that prescribes certain legal requirements. Redistribution is enforced through an act that requires certain legal requirements. We know, colleagues, and we must be honest about this. We know that the restitution program is severely overburdened and buckling under the weight of the claims that it needs to resolve. We know that the redistribution program has not gotten off the ground in the way that we had hoped. And we know that the legal instruments that we have crafted have only done a part of the job. And so my plea to this gathering would be that the Chapter 9s and the Human Rights Commission consider how it is that we can think about supplementary interventions in addition to legal interventions. Colleagues, the law is not designed to heal wounds, right? We must be honest about that. The legal system is designed to create a situation of winners and losers. It is designed for specificity, it requires particular levels of evidence, and it requires particular outcomes that can be adjudicated and gauged. And in all of these processes in the land reform project, there will always be winners and losers, which means that the nation's psyche, the historical wound that we carry around land, is not actually being healed by legal instruments. And so I would urge Chapter 9s to think about what are the other mechanisms that we can use. Imagine, if you will, a caravan that travels around the country that allows people to express the pain of the history of their dispossession, whether it's in art form, dance, poetry, merely telling their stories, having those stories recorded, kept somewhere, built into the story of the nation. What you would be doing is you would be providing people with an alternative outlet for the pain. Anybody who has worked with restitution communities knows that what they put forward is a long story of dispossession, and what actually ultimately goes into the claim is but a slice of that history. And you will see that what people are seeking is not just, of course, restoration and redress, which they are entitled to, but they're also seeking affirmation of their pain, acknowledgement of that pain, and for it to be heard. And so it seems to me that this provides an opportunity for the Chapter 9s to lead in how we think about what are the other alternatives. Our land reform system, as it currently is structured, is struggling. And yet the pain of the national psyche remains, and how else do we seek to address that outside of the law? I'm not undermining the law or saying that we should abandon it, but I am saying it is not a complete and adequate tool to address the wound that we're working with. Chair, my final point is around Section 25, and the question that was put to us around the need to reimagine Section 25. I would make 2 points. The first is that I would make the plea that we not rush to reimagine Section 25. And by reimagine, I'm talking about making amendments, making edits, adding sections, adding words, etc. What I would plead with us to think about is reimagining how we use Section 25. And in particular, I would put to this gathering the following challenge. Section 25 has been constructed and construed in a way that sets up an internal tension within the section. Sections 25(1) to 4 have often been considered to be the provisions that are about protecting those who have land and property, whereas sections 25 to 9 have been considered as being about land reform, redress, and restoration. I don't think that that structure is an accident, 1, and 2, I don't think that that structure is a weakness. I think that the task at hand here, and again, this is where the plea comes into this gathering and to the Human Rights Commission, is to consider how it is that we can shape the relationship between Section 25(1) to 4 and sections 5 to 9 of Section 25. Because it seems to me that there is power in a different articulation of what that relationship is. Currently, it's been constructed as the first part is about the haves and securing white wealth. The second part is about, oh yeah, okay, let's try and restore black people. That hasn't worked. That reading, that interpretation has not worked. And I don't believe that it's the only interpretation. And so the plea would be that we think about how we can reimagine the relationship between the front part of Section 25 and the latter part of Section 25 that grapples with land reform. What is that relationship, and what does it need to be for us to advance land reform? We see, political actors stepping up and defining that relationship, right? Casting this narrative of Section 25, 1 to 4 being about preserving those who have, and 5 to 9 being about redress. It's clearly time for a different interpretation, for a reimagined interpretation of what the relationship is between the front part and the latter part of Section 25. And this is the work that I would hope some of us at this convening could do, but also I would hope that it's the work that the Chapter 9s and the Human Rights Commission could apply its mind to. Chairperson, in the interest of time, I am going to stop there and say thank you very much. Thank you.
Thank you so much, Nolundi Luaya, for that very lively and powerful presentation and plea, not only to the South African Human Rights Commission, but to the collective of activists in all platforms that are looking at and dealing with the question of land, to center those who are most affected by the history of dispossession. Thank you very much, Ms. Luaya, and thank you also for trying to contain your presentation within the allocated time. We very much appreciate your contribution. Colleagues, I will then want to move on to our last speaker from Women on Farms. Welcome, Carmen Lowe, to the podium. We look forward to your presentation, and we thank you very much for honoring our invitation. Over to you.
Thank you very much, and good morning, everyone. So it's difficult to speak after all these speakers, but as our name says, we work with women who live and work on commercial farms. They don't own farms. They are also not eligible in terms of restitution, and because they were dispossessed of land way before 1913, because many of them are the descendants of slaves, and therefore don't qualify for restitution. So, but we do believe that the Constitution do make provision for land access to women and people living and working on commercial farms, but there's a lack of proper legislation to give effect to that. In terms of Section 25, and previous panelists spoke about equitable redress, we do believe that that section can be used to effect legislation, and colleagues from Legal Resource Centre has done research on the lack of land redistribution legislation. So we believe that if there's proper land redistribution legislation that also prioritizes women, and especially black women in rural areas, it will go a long way in alleviating or towards proper land redistribution. And just to note that we have this gathering at the end of August, end of Women's Month. And as previous speakers said, women are the most affected by the lack of access to land. And statistics will also show that they are that they've benefited the least from land reform. And having that in mind, just a few days before Women's Day, a woman killed herself and her children because of poverty and a lack of food. And I think it is a scandalous that we, in a country that exports food and that makes a big contribution, where export of commercial agricultural produce contributes to the economy of this country, that people can still die because of hunger. I've also just returned from the Northern Cape, supporting work in our Northern Cape office, and there during off-season time like now, when there's no work for women, seasonal workers, women walk for kilometers to the nearest abattoir to collect meat or meat that is not fit for commercial sale, and that is your small and large intestines that nobody really eats, but they collect that for free in order to feed their families, because there's not sufficient household income to sustain families during off-season periods. So it is a timely discussion. This discussion has been input over many years, has happened. South Africa is a signatory to many international conventions, as was fully articulated. We've got a very progressive constitution, and by many international standards, Section 25 would seem adequate, but the reality is land inequality is growing, and also socioeconomic inequality, and women suffers the most. So the question is, what needs to happen? I don't know if we've got an answer to that, and whether we'll continue this discussion in 10 years' time with greater inequality and more women dying because of hunger. We've also seen the maps, and if we look at the maps and even the areas, if we look at the Western and the Northern Cape, the initial map showed no dark areas because there was no land allocated to blacks, because most of the land in especially the Western Cape belongs to white commercial farmers, and that spans from colonial times, because the initial mandate of the colonizers was to create an agricultural system to support their greed and their exploitation, and that is still the status quo today. Also, very little land reform happened in the Western Cape, in particular in commercial farming areas. So despite the progressive laws and treaties. As women on farms, we believe that, as I said, Section 25, there's still a room for maneuver to use Section 25, but with different interpretation or added interpretation. I'm going to jump over most of these pages, and I want to focus just on international law, and I'll use the United Declaration for the Rights of Peasants, or UNDROP in short, that was voted in by the Human Rights Council in 2018, and then also by the UN General Assembly in 2018, and our country also signed, South Africa also signed or is a signatory to that. Despite that, nothing progressive has been implemented to give effect to those laws, or to effect the declaration or the stipulations in the declaration. So why is UNDROP important? It specifically recognizes and highlights special protections for rural women, and it envisions an alternative agricultural system than the current mode of commercial agriculture that perpetuates structural inequality, leads to food insecurity of those working the land, and harm the environment, causing lots of diseases and deaths, without victims or their families receiving any compensation. It also leads to mass displacement and the creation of slum areas, and perpetuate feudal and colonial land work relationships. So the current land reform process that's happening for commercial farming areas continue to see just one mode of agricultural production. And I think it was this first panelist that spoke about agrarian reform. None of the government's land reform processes acknowledges real agrarian reforms that sees a different kind of agriculture. Agriculture that is not dependent on large-scale export-driven agriculture, but more small-scale, and there's sufficient research that supports small-scale agriculture as a way to eliminate food insecurity. So the particular sections of UNDROP that I would like to refer to is Article 3. It's a general equality and non-discrimination clause against peasants and people working. But the reality is rural people and people working on farms are still stigmatized. They still struggle to access institutional support, access justice, which I'll speak about shortly. Article 4 is also no discrimination against women, which is supported by our Constitution, and it's mentioned in various acts. But the reality is there's very limited real processes on the grounds that support that. For women working on farms, their dignity is daily violated. They don't have freedoms. They can't come and go on farms as they please because the property don't belong to them. And there I just want to add or concur with the Section 25 rights, the property rights versus the rights of those who must still be beneficiaries of Section 25. Our courts and the way it's interpreted, even the way our legislation is written, favors the property right as an absolute right, whereas tenure rights and those who are fighting for rights are seen as lesser rights and not the equal constitutional right as those with property rights, absolute rights. So they don't have the same freedom in their workspace. They don't have toilets. Their livelihoods, seasonal work don't provide sufficient sustained livelihoods, which leads to poverty and food insecurity through certain parts of the year. And although there are various laws stating that this shouldn't happen, the reality is it still does, and there's very little institutional support to combat that. Then the right to liberty, to life, liberty, security, and of person, Article 6, the right to life, also refers to physical and mental integrity. For a woman living on a farm who don't have constant income and don't have constant food, it affects their and their family's physical well-being, but it also places a lot of mental stress on women. And from research and engagement with farm women, there's also the legacy, besides legacy of the TOT system, also the legacy of intergenerational violence that nobody deals with, and that sits in the bodies of women and is still being perpetuated, if not by the farmer, by the male person who she's dependent on, because tenure security on farms, housing contracts is also only reserved for males. So if a woman wants to live on a farm, she needs to move in or take a man. If not, she will be evicted, and so I am very short of time. So, but there's the various, also it speaks of a right to safe and healthy work environment. Just a few weeks ago, we had the UN Special Rapporteur on pesticides and toxins in the country that confirmed what's been said about the exposure. South Africa allows harmful pesticides and active ingredients into the country that's banned in the country of origin. So those countries see those pesticides and harmful substances as harmful, as cancer-causing, as respiratory problems, all kinds of problems, that our government still allows those pesticides to be used and expose numerous farm workers, especially women, to various diseases and fatal outcomes. Right to food sovereignty, to choose what kind of food we want to eat, a right to decent income, house. But linked to that, the main thing is the right to land, Article 17 of UNDROP, right to land. If women have independent land, they will not be dependent on a male. It will decrease their exposure to gender-based violence, and they will be able to independently secure food for themselves and their children, and not be dependent on a farmer or man. So what we propose and recommend is that the Human Rights Commission support agrarian transformation that's not dependent on commercial agriculture. Also support people-driven land reform from below, where laws are interpreted and Section 25 is interpreted from a perspective of the disadvantage of those who do not own or those who do not have secure rights to land, and not to protect the absolute right of property owners. Also settlement support, redistribution, and also in commercial farming areas there's lots of unused state farms. We are currently supporting a community that lives on Transnet, a parastatal land. Transnet is evicting them from that land. Farm workers, seasonal farm workers, and we met with a judge 2 weeks ago, and even he says it's a disgrace that a parastatal is evicting farm workers. So this is my just the final point I want to make. Although there is support, there's also one of the UNDRAP points is access to justice and legal services. So although there's access to legal aid and legal services, there's still inequality, judicial inequality. And although, because ESTA is one of the acts that comes from Section 25 to secure tenure, but there's an unequal implementation of the act. Because when people are evicted, they feel the full might of the law. But when there's illegal evictions, police are reluctant, not even reluctant, they don't prosecute landowners who are guilty of violent illegal evictions. The same with access to courts. Yes, there's legal representation. But for people from farms to get to a court, traveling here last night, and even when I arrived, there's a matter before court today. Farm dwellers don't have the resources to get from a farm to a court in Cape Town. They heard yesterday they must be at court today at 11. For seasonal workers without an income just to get there is a story on its own. And then every year during budget speeches, we have budget cuts of the Department of Rural Development and Agriculture. So these all have a real impact in securing justice for those who don't have secure land rights. I thank you.
Thank you very much, Ms. Carmen Law McKay. Colleagues, the time is now 34 minutes after 11, and we were scheduled to end our session at 15 minutes after 11, post a discussion session amongst us all. We have had a discussion as the organizers, and we have decided that in order to be in respect and in the right side of time, we will still keep the discussion session, but we will combine it with the next panel discussion that will take place after our tea break. On that note, then, I must thank our panelists for the very powerful inputs that they have offered us this morning, all the way from Dr. Chanel van der Berg, who offered us an international perspective on issues surrounding land and the role of South Africa as a nation in the global perspective when it comes to land discourse. But we must particularly thank you, Dr. van der Berg, for also highlighting the plight of human rights defenders who are working in areas surrounding the right to land, especially for indigenous communities in extractive industries or communities affected by extractive industries. We must also appreciate your highlighting of climate change and its effect on the ways in which we think about land. The ways in which climate change affected us in 1913 is very different to the situation today. And as we consider the legacy of 1913, it becomes quite imperative for us to also consider the ways in which the landscape has been affected and changed by climate change, especially for vulnerable groups, including women and indigenous children. You also must appreciate your note on the need to accelerate land reform and also some of the concerns that you have raised as an institution, particularly on the Traditional and Khoisan Leadership Act. Thank you very much, Dr. Van Bitberg. We must also thank Ndifuna Ulwazi, Ms. Rabwane, especially for bringing in this notion of the urban landscape and the legislative lacuna when it comes to dealing with the issues of urban land reform, noting that 64%, as you have noted, of the population is residing in urban areas, and the projections are that by 2030, more than 70% of the population will be in urban areas. The question you have put to us is, what is it that we are going to do, not just as Chapter 9 institutions, but as a society, in ensuring that as we experience a situation of urban migration, those who are migrating and those who are inhabiting urban spaces, their rights to land are protected and promoted. So we thank you very much, Ndifuna Ulwazi. We also thank you for some of the proposals that you have made, particularly with regards to the donations of land by the state, the security of tenure, as I have mentioned, as well as the need to enact legislation to address this legislative lacuna that you have highlighted. Ms. Nonondiluwaya, we thank you for your very lively presentation, as well as the graphic representation of exactly what it is that we are dealing with. Most often when we do not see the graphic representation, it's easy to not have a true appreciation of the exact violence of this 1913 Natives Land Act to relegate 90% of the population to about 10% of the land is extremely violent, and it breeds the kinds of socio-economic ills that we are still experiencing today. And as we have rightly pointed out, if these are not addressed, not just by law, these are the situations that we are also going to breed, maintain, as well as sustain and reinforce for our future. So we thank you very much, but we particularly thank you for the plea that you have made to us to not give up the fight, but to also center the voice of the dispossessed in the discourse, highlighting also that the law alone is insufficient in dealing with the problems of the nation, especially as they come to land. They are complex, as highlighted by Dr. Van der Berg as well, many of them cultural, many of them spiritual, and these have to be addressed from a perspective that does not only center the law, but recognizes that there is a multiplicity of understanding and multiplicity of solutions that need to be brought to the table for us to move towards a transformed society that we request and we require. Lastly, we give thanks to Women on Farms, Ms. Carmen Lowe McKay, for your contribution, particularly putting the focus on the effect that land dispossession has on women. You also uniquely pointed to the relationship between land and gender-based violence, land and agrarian reform and food insecurity, which are pertinent issues in the current landscape, as we pointed out in the days leading to Women's Day. There was a woman in the Eastern Cape who unfortunately committed suicide due to food insecurity. And that is just one case amongst many across the nation of the effects, the devastating effects of landlessness, land dispossession, and the legacies therein, and the relationship between gender-based violence and insecurity of food and land. We thank you also for some of the recommendations that we have made, particularly as they pertain to agrarian transformation, land reform from below. And that speaks also, and it complements the recommendation made by the Land and Accountability Research Center through Ms. Luwaya to say that though a bottom-up approach that considers and centers the voice of not experts, but the voice of those who are most affected, who are usually poor and relegated to communities in the outskirts of the centers and the urban metropoles, are those whose voices we should be centering. We very much appreciate all of your contributions as panelists this morning. We can assure you that as the South African Human Rights Commission, we will take your very considered recommendations, and not only will they find themselves expressed in our report, but they will also find themselves expressed in the recommendations we make to the state, as well as the monitoring and following up thereafter to ensure that we move a step forward away from the legacies of the 1913 land. With that, I thank you very much. And as indicated earlier, the question and answer session will be joined together with the next panel that will follow from the break. For now, I hand over to yourself, Program Director Dr. Nzo. Thank you very much, colleagues.
Thank you very much, colleagues. As we have heard, we will take the discussions forward once we come back from the tea break. So right now we're just going to have a 10-minute stretch and just go outside and get some refreshments. You're more than welcome to bring the refreshments inside because we are really pressed for time. So let us return after 10 minutes and then we get to our next panel. Thanks. From here? Really? Yes. He was in Benoni, my uncle. Yeah?
Because I just thought of it when I saw your name on the program.
We're a very small family, so if you see somebody in Zor, you must know that for sure, for sure.
No,
I've got to know that person. It's a small world. When you see him next time, I say, no, I met with your niece. Yeah. Ladies and gentlemen, I think we can start as we move on to our next panel. While we are waiting for everybody to come in so that we can settle in, I was really quite fascinated by the previous panel because, you know, when Chanel spoke about issues related to climate change, and how they actually threaten, you know, food production security in South Africa, it really made me think about another aspect of climate change, which is the decarbonization of our economy, which is the renewable energy sector. I've been doing some research in that sector because it also ties in with land-related issues, particularly if we're going to look at the wind farms and the solar farms that need to be developed and erected in this country. And here, when I saw the map that was illustrated by Ms. Luaya, and it took me back to the research that I did in the Northern Cape, because what is interesting is that although when I was going through research and looking at what other African countries are starting to experience with the renewable energy sector, such as Morocco and India, you find that most socially deprived communities who are in these rural areas are actually, you know, compelled by their governments to move from these areas so that they can actually make space for the development of the renewable energy sector. And now it really talks about the issues related to the history and the patterns of how history informs the future and the repetition of land dispossession, because these rural communities are actually compelled and to a large extent forced to move from their areas. And that also threatens their own ways of, you know, ensuring that there's food security and they continue with their agricultural lives. But in South Africa, it's a different case, because in the Northern Cape, as the previous speaker spoke about the issue of the private land that is in the hands of private commercial farmers, Ms. Carmen Lowe, she also reminded me of the outcomes that I saw, that because of the slow pace of the land expropriation, there are commercial farmers in the Northern Cape who have substantially benefited from the renewable energy sector, to the extent that they are making anything between 500 and R1 million per month. Now again, in the South African case, it really talks about the historical reproduction of unequal distribution of wealth as a result of lucrative commercial land still belonging to the minority. So I thought I should actually, you know, bring this up, because I think this is one area that talks about land, particularly when it comes to this issue of expropriation in South Africa, where we are seeing that reproduction of inequalities and economic inequalities. So I think this is some aspect that we should be looking at quite seriously, so that we can get to understand the ramifications of the climate change agenda when it comes to land dispossession, and economic inequalities. But ladies and gentlemen, let me welcome the next panel, since everybody now is settled in. Our panel number 2 will be unpacking the work of relevant institutions that deal with the issue of land. Now, amongst our panel members, we'll be calling you one by one, and you can make your way up to the podium. We will start with Mr. Teres Ndove. He is the Deputy Director General responsible for land redistribution and tenure reform from the Department of Agriculture, Land Reform and Rural Development. You can make your way up to the stage, sir. And then we will have Mr. Cameron Jacobs, who is the Chief Director for Governance and Monitoring from the Public Service Commission of South Africa. So there's just a change there on the program. Can you please make your way up to the podium? And we will have Ms. Nomfundo Ntloko Gobodo, who is the Chief Land Claims Commissioner for the Commission on Restitution and Land Rights. You can also make your way up to the podium. And this session will be moderated by Ms. Fatima Kohan, who is one of the commissioners, and she's the Deputy Chairperson of the South African Human Rights Commission. So let me hand over to you, Commissioner Fatima, and you can take over. Thank you very much.
Good morning, everybody, and thank you all for getting back on time so that we can proceed with our agenda. In the Human Rights Commission, we like to say that everybody has got rights, but there are equivalent responsibilities. And I want to just arising from the last session, ask all of you to engage in your right to be here, to participate, but when you are here in the plenary, to also have the responsibility and respect to switch off your cell phones and to please not do any surfing while we are in session. If you need to use your cell phones, please discreetly walk out, because I do think it's very disturbing to the panelists when they are at the podium, when we hear music and other interruptions. So if we could abide by that. And then, of course, the panelists likewise, rights and responsibilities. Can we try and make our point in the first part of the input so that everybody is paying attention? There was research done that says that the human brain can only concentrate for 5 minutes at a time. So beyond 5 minutes, if you haven't made your point, nobody's going to get you anyway. So it'll just help, because we have a long 2 days ahead of us, to ask you all please to likewise be cognizant of that. Without any further ado, let me thank the panelists for being here from the institutions that we have. They have been introduced already by Tina. And may I then call DDG, would you like to take the platform first, followed by the Deputy Chairperson of the Public Service Commission, whereafter the Chief Director of Governance and Monitoring. Sorry, that is you from the Public Service Commission, whereafter the Chief Land Claims Commissioner, Ms. Ntloko Gobodo Nomfundo, will take over as the third speaker. Whereafter we will have a question and answer session combining both sessions 1 as well as session 2 this morning, which I will preside over. So thank you very much. Over to you, DDG.
Thank you so much. Let me try to accommodate my given advantage of height. Thank you so much, and let me take this opportunity to thank the moderator, the chair, commissioners, and all the members that are here. I'm very much given a strict direction in terms of time, so even my greetings will be very, very short so that I get to the matters for discussion. As indicated, my name is Teris Ndove. I'm responsible for land redistribution and tenure reforms. And I'll take you through briefly in terms of what we are doing. That will form part of the... I want to be able to see this site as well. Maybe they can. Is it possible to push it backwards?
Can you use this and then you can look?
Okay, but
Would that be all right?
it is good to face the audience. Yeah, thank you so much. Thank you so much. Thank you so much. That is the outline. I'm not going to dwell on it. In terms of the also guidelines that were given, I would focus on issues that talks to redistribution. My colleague here is going to talk to tenure. To restitution. I'll talk to redistribution and tenure only. Progress made, and also challenges and plans to try to address matters related to land. There are also issues that we look at. What are the overlapping functions that we have working together with other institutions and departments. This has already been emphasized that we are here because of the Native Land Act, which was enacted in 110 years ago. And it brought in challenges that we also continue to face today, especially the triple challenges, which is unemployment, inequality, as well as poverty. And we know that the liberation struggle was actually centered around land in this country. We also know, which is very important, that our settlement was a negotiated settlement. And in itself, the settlement in itself already laid down some policy framework in terms of how the constitution of this country should be developed. And obviously the constitution becomes the main center that also affect what we can call land reform today in this country. Just running in terms of the overview of land reform in our country, South Africa has got two distinct tenure systems. The previous speakers have already spoken to that. The other one is the well-organized, and I think it was said is private land, well-organized within the cadastral system and with the secured tenure. That is the other one. The other one is the one that is, the land is, if it's registered, mostly it will be registered up with the state, but communal owned in most of the area, in most times, and not surveyed, and that is the area that talks to the 13% of the population, and mostly 13% of the population in our country. And this is the two challenges that have been inherited. And part of land reform is also try to address these challenges as we speak. In terms of the Section 25, which has already also been elaborated, there are obligations, especially the two areas that have already been stated, one on the property rights as well, the other one also on issues related to land reform. That this government has got an obligation to enact enabling legislation that actually address these challenges that we have. Just a brief status, this is 2017. I don't think things have changed so much, but I think they're almost the same. There was an audit that was done, and let me qualify the audit by removing what is not here. What is not here is trusts and companies that own land. They are not here. What is here is land owned by individuals, and which constitute 39%. So that means we've got a bigger part of the land that is not accounted for. So we're only talking about individuals. In it, 72% is owned by whites, 15% by coloreds, and 4% by Indians, and 5% by Indians and 4% by Africans, or we call them blacks. I don't want to talk about how many blacks we have and how many whites we have. You can make those analyses. Time does not allow me. Again, issues of women were emphasized. In this audit, only 13% of the land is owned by women. So the rest, you can tell me who owns it. That is another challenge that we have in this country. Part of what we're supposed to do is to respond to, recommendations by various institutions, including Chapter 9. There are many. I cannot go through all of them. I just picked some few, especially that came through the Presidential Advisory Panel, which is the latest report. I think that's 2019. It's fair to look at it. One of the recommendations, trying to move as quickly as I can, it was the issue of what can be regarded as unfair allocation of land to beneficiaries, that we should develop guidelines that actually ensure that there's equitable, distribution of land to beneficiaries. And in response of that, beneficiary selection and land allocation policy was developed, and it has been approved by cabinet in 2020. In it, more specifically, is who are being targeted. I'm not going to. It's available. It's available on our website. We can look at it, but it's more that it's targeting women and young people, and also people that are living in communal areas. Those are the key targeted, and to that extent, 50% of the land that we allocate is supposed to go to women. I think that's what's important with that. And the next one is regarding the release of land, and I know it has been said as well from state, yeah. And the department also did release land, about 700,000 hectares, and which was also distributed as indicated there. The issue of land donation also was part of the presidential panel recommendation that there are people that needed to donate, but there was no framework in which how they should donate. A donation policy has been developed, and also it has got some level of incentives to ensure that those that donate don't get penalized, especially in terms from the tax side of things. However, the process, I need to say, is very slow. It looks like some people wanted to use that to also bargain for some other issues, which goes beyond what the donation policy can do. Issues related to in areas, the 13% areas that we talk about, communal areas, in terms of we know that the Clara that we had was discontinued or declared unconstitutional in 2010. That is one area. We also talk about the IPILRA as the functioning legislation. There's also suggestion about that. I will also reflect a bit about it in terms of what is the position now with regard to that. The IMC actually, of which has been established led by the Deputy President, actually directed that there be a study especially in the African countries, but also taking international experience in terms of how to deal with matters related to communal land, as well as the administration of it. Because it's one thing to give land, but it's another to deal with the issues of administration. So as part of trying to again resuscitate the enactment of enabling legislation. That has happened, and that led to the conference, or called it a summit, that was held last year. And part of it is the intention is obviously to enact any legislation. And that process is still going on as we speak. In terms of enhancing the security of tenure, especially using the ESTA, there's a farm dweller program that has been developed, which actually try to bring in all the key stakeholders in addressing matters that affect people that are living in farms, as it has already been outlined, to protect their rights as farm dwellers and also to provide them with permanent and secure tenure. There are key 5 pillars. I'm not going to talk to them, very clearly indicated there. But what is important for this to be implemented, you need various participants to ensure that this happens. The Nkuzi judgment that we all know directed that we have to provide legal representation to people that are affected by ESTA, as well as the restitution, as well as the labor tenants in terms of land reform. That has happened, but of importance is that this process, yes, actually started some time ago, but as we speak now, this function has now been transferred in the main to Legal Aid Board, or LASA, Legal Aid Board of South Africa, LASA, and this service is still continuing. I thought it's important to mention that. From the labor tenant side, we are, because of the process that was low, there was a judgment, the Mvalaza judgment, that compelled the department to have the special master that must supervise, monitor, as well as oversee the work of labor tenants. That is done, and we have complied with that, and that is going on. From the land redistribution side, provision of Land Assistance Act, which was indicated that is not sufficient to deal with a Section 25(5) in terms of land redistribution, which we agree. But this is the current legislation that we have to use in the absence of the land redistribution legislation. Again, with respect to matters around the Section 25, we've traveled and with different phases. And I'll just be very brief. When we started, there was RDP, platform where people were given grant. At that time, I remember it started somewhere around 15,000, 16,000, and people have to come together. That means we have to have big community coming together in order to contribute their 15,000 to get land. And that land was transferred in title. The second one we moved on to where we speak about blended funding, meaning that there was a portion provided by government as a grant, as well as contribution from those who want to benefit. Obviously, it will reduce the number, but it forced people also to raise money through banks, and at the end of the day, there were challenges. But that is where that's what happened. And lastly, we landed up where we are now on the leasehold arrangement, which government buys farms and lease them to. There are challenges related to that, but because of the time that I don't have, I just need to move as quickly as I can. In terms of legislations and also addressing the gaps, there's been an amendment to ESTA to ensure that it accommodates the interaction, like I indicated, of various people in securing the tenure rights of the affected communities. Establishment of what we call land right management boards. These committees actually include various people in order to make sure that it is not only a government that participates in this process. That is part of the amendment that was done in 2018. Also part of the amendment is also to look at the strengthening the rights by making sure that there are alternative subsidized accommodation, issues of farm dwellers' rights, and other related matters. Those are also some parts of the amendments that have been effected in 2018 on the ESTA. With IPILRA, I just want to indicate, indeed, EPILRA is an interim measure. We're not supposed to be using it, but I'm also very happy to hear that it's a very strong act, although it's temporal. And I also agree that while we're working on the permanent solution, EPILRA should be strengthened by developing regulations. And that's what's currently happening. So we have heard you, civil society, what we have said, and we are trying to do exactly that. In terms of how the other legislation will be, it takes pressure on the other side because we will be having something that is a bit stronger and it has got regulations. And we will then move on the development of the legislation, which will be permanent arrangement. In terms of the land redistribution policy, again, we also accept, as I've indicated, we're using the Assistant Act 126 currently, which is not sufficient and which we agree. But as we speak, we're busy developing through the necessary processes of the policy as well as the legislation that will now actually address the section 25.5, which is the redistribution. That is the only area where we don't have any legislation in our constitution. And in it, very important is that, as I've indicated already on the beneficiary selection, which will obviously will also form part of what's going to be on the legislation, is the targeting of vulnerable people as our biggest target for land redistribution. Progress to date, quickly, from 1994 up to now through this program, we have acquired 5.2 million hectares of land, both in terms of freehold as well as lease. In terms of lease, it's about 2.2 million, the one that is on the leasehold. The rest is on freehold, meaning that it has been given. I heard the word, people should be given land. So in this case, I'm talking, that part has been given to people. The 2.2 is an area which part of it has been given and part of it we are still giving. Because also on the leasehold, the ultimate is to transfer. So I just need to make it, is to acquire, develop, and transfer. So as much as the leasehold, but its end is transfer the land in freehold to those people who qualify. Well, the other important thing is to indicate that between from 2019 up to now, we have acquired 245,000 hectares. And this is mostly in leasehold, but also include part of tenure as well. This is the same figures that I've indicated. Just a breakdown in terms of provinces and also those that are plus are the ones that are under leasehold, and the rest are the ones that I've also already indicated. This is what we acquired currently between 2019 until now. And you can see there, I'm not happy about representation of women in terms of allocation, but they are. If we look from where we are coming from, there's a lot of improvement, but we can still do more in terms of ensuring that women and youth and people with disabilities are actually prioritized. What are the constraints, challenges? I'll be very brief. I need to indicate, when we started, I said we are living in a society informed by a negotiated settlement and the Constitution. And in it, it talks about government have to have a budget in terms of land reform, have a budget, and go and negotiate to buy a land from those who've got land to address any form of land reform. That is the arrangement we have. And it means if the prices are higher, the land will get smaller in terms of the output. What we are having is that we have got people that are very reluctant in terms of releasing land. We have got also challenges with regard to prices that are getting very exorbitant. We also have got of landowners, especially on the tenure side, who sometimes even refuse to recognize the presence of labor tenants in their space, or even when the claim is there, it actually denied the claim. And what happens? It must go to court. And those that agree that there's a claim, we differ sometimes in terms of prices of the land to compensate their land, and again, it goes to court. Those are some. We've got also challenges with land invasion. We also have got huge challenge, and this cuts across. I believe my colleague will also talk about it. Post-settlement support. That's a huge challenge that we have because tenure, security of tenure, is not food. It's just a right, but that right must be supported by something else for livelihood of those people. And that is a challenge that we have, and also the infrastructure on the land that we have acquired. As I conclude, I'll just indicate that we are working on the two great policies as well as the legislation, one on the redistribution and the other one on tenure. And we believe as we move forward, we will be able to engage. We started engagement with academia and other people, but obviously the process is still at its initial stage. We will engage, and most of you will be part of that process as we move forward. And that's how I conclude. I hope I used my 10 minutes effectively. Thank you so much.
Good morning, everybody. Hope you can hear me. Okay. How do I start this? Thank you. The Public Service Commission. My name is Cameron Jacobs. I'm from the Public Service Commission. Part of our mandate is to investigate, monitor, and evaluate the organization and administration of the public administration and the public service. And yesterday we were at our strategic planning. And one of the guest speakers at our strat plan was Dr. Ivor Chipkin. And one of the poignant things that he actually said at our strat plan was that real policy making happens when we discuss causes, when we move beyond description to the analysis of causal variables. And there's a reason why, and you will hopefully work on that a little bit later about why I'm saying this. So in the morning session, we spoke about a number of different issues: climate change, gender-based violence, Cape Town in particular, social exclusion. And we're linking this to Section 25 of the Constitution. And I wonder whether that is appropriate to actually link it to Section 25 of the Constitution. The Public Service Commission also is involved in coordinating the national implementation plan on the professionalization of the public service. It was a document that was adopted by Cabinet in October 2022. Because there's a realization that the public service and the public administration is not as professional as it ought to be. And there are three core facets to the professionalization framework. It's character formation, right? How we behave ourselves and our conduct as public servants and public administrators. The other one is capability, both human resource capability as in the public servant, and where they have the qualifications and the aptitude for the job at hand, as well as institutional capability. In other words, the organization and structure of government. Whether the Department of Land Affairs or Department of Rural Development and Agriculture, Agriculture, Rural Development and Land Reform is appropriately structured to do what it's supposed to do. Whether the Commission on Restitution of Land Rights is appropriately structured to do what it's supposed to do. And the other one is on public sector reform, reviewing legislation, reviewing policy. The Public Service Commission also got involved in the whole land question in around about 2018, when we were approached by the then Deputy President to trying to look at the blockages attached to the land reform program, and we produced a report. We produced, in fact, two reports. One was on the post-settlement reform, or the post-settlement process, and the other one was just looking at the performance of the Commission on Restitution of Land Rights. And we've engaged with both the Minister and the Commission on Restitution of Land Rights. In 2000, early 2000, I was involved in a project when I was working for Surplus People's Project. I was involved in a project, a land project, looking at the, from my side as a researcher, trying to understand the particular rights of the people on the farm. But we were Surplus People's Project together with the Legal Resource Center and the Environmental Monitoring Group went in there. And the purpose was to try and secure development assistance, a land reform grant. So we unpacked the rights of the particular beneficiaries. We facilitated through a particular sort of rural appraisal process the conditions on the ground. And we asked beneficiaries what they wanted. And this was in the Northern Cape. I know people spoke about the Northern Cape. Very arid. And they were seasonal farmers. They have this patch of land, this farm, but they were seasonal farm workers. At the end of it, the decision was that they need to plant rooibos tea. And they got development assistance to plant rooibos tea. They entered in a cooperative agreement with neighboring farmers. So they planted, harvested rooibos tea, and it processed by neighboring farmers. That proved successful. So later on, through the Environmental Monitoring Group that had connections with Europe, they were exporting rooibos tea to Europe. Later on, they sort of marketed locally. And there was a time, and I'm quite sure if it still is, but Pick n Pay was selling a Pick n Pay branded rooibos tea that came from that very farm. Now that's a successful process of land redistribution or land grant and development assistance. There's a school of thought by this academic called Maller that economic growth is not going to come from your urban center. Economic growth is in fact going to come from your rural periphery. And so I started off with what Ivor Chipkin said, but real policy making, we need to look at the causes. Because part of the problem that we have, and I don't want to go necessarily through legislation, etc., is about how we implement policy. And do we actually understand the causal variables in the policy? Because that for this is the key. In the first session we spoke about, like I said, gender-based violence. We spoke about issues of housing actually. We spoke about issues of economic and sort of climate change. And it's not exclusively to Section 25, is it? It relates to Section 26 in terms of the right to adequate housing and access to adequate housing. And so when I spoke about now the mandate of the Public Service Commission about looking at the organization and personnel practices of the public administration, because we need to think about carefully about cooperative governance. Because is the question about Section 25, in the Section 25 in terms of the land reform program is quite specific. It deals with tenure security, it deals with restitution, and it deals with redistribution of land. And I know there was a discussion around whether Section 25 should be amended. The Public Service Commission's own research in terms of the performance of the Commission of Land Restitution suggests that Section 25 is not actually the problem. Rather, the key problem is how government in its entirety completely underestimated the entire land reform program. It underestimated the land reform program, it underestimated the complexity of the land reform program. The 1998 ministerial review on the slow pace of the land restitution process, two parliaments said there's a crisis of unplannability, that the government never actually expected the total number of claims that it received. 79,000 in total when it was unbuggled. How is that possible? We just had in the first session the entire history of our country, that land dispossession was at the core of our segregation and apartheid past. How is it possible that government misunderstood So what did that mean? It meant that organizations, government organizationally was not fit for purpose. If you look at the commission right now, the Commission on Restitution of Land, majority of the commission staff is seconded from the Department of Agriculture. It does not have enough resources. It does not have enough skill. It does not necessarily have the technical ability. But we're dealing with 79,000 claims. At the moment is about, Nomfundo can correct me, but about 7,000 old order claims. At the time of the writing of the McClunty report, it was 9,000 old order claims, and he said it's going to take about 35 years to resolve those claims. And we're still dealing with 2014 claims that must come our way. And for me, that is the issue. It's not necessarily, so we can't always look at Section 25. I think that in my view, and this is my personal view, it does represent a fair balance between the protection of private property, and yes, it was a result of a negotiated settlement. But the land reform program is also in the public interest for a public purpose. And I don't think we can honestly sit here and say that we utilize that provision properly. It's an important and powerful provision. At the moment, almost 30 years, the Restitution Act was promulgated in 1994. 30 years, we're still having a debate about expropriation. We're still having a debate about just and equitable compensation. Why has land not been expropriated in respect of the Constitution? Maybe Nomfundo can answer that question. Because it's entirely possible. But often when you look at particular court cases, land claims cases that come before court, or negotiations around just and equitable compensation, the first port of call by the state is, we can't afford it, it's prohibitively expensive. And then as the case drags on and on and on, there seems to be a change of mind and a change of heart, and suddenly there's affordability. So in respect, if land reform program is about equity, it's about social justice. It's about redressing the rights or the wrongs of the past. Why is it that we continue, particularly I'm not talking about land redistribution now, because that is sort of willing buyer, willing seller, but I'll get back to that a little bit later. But we continually speak about the willing buyer, willing seller in terms of restitution matters, and I just don't understand why. There's a part of it that is restitution, that is willing buyer. But when you're starting off on the premise and you want to negotiate with the landowner and say, do you want to make your land available for restitution purposes? Why do you do that? You're providing them with an option when you actually have the expropriation, and the land claim is against the state, is not against the landowner. So you're really offering them the option to say no. Why don't you say, well, in terms of just and equitable compensation, in terms of case law, right, we're starting in the premise of the market value. This is the market value. Now the court can adjust it up and down depending on the current use of the land and the history and use of the land. So to a certain extent, it's how we decided to go ahead with the land reform program. If Mele is correct, that economic growth is going to come from the rural periphery, why have we not done anything to try and develop the rural periphery? Why are we focusing on the urban center, where we know there are extreme problems in the urban center with immigration? I want to deal a little bit with cooperative governance because I think I'm going to be running out of time soon. I'm already out of time. But just in terms, when I said sort of cooperative governance, why isn't there that proper relationship between the Department of Human Settlements and the Department of Agriculture, Rural Development and Land Reform? Why is there not a proper relationship with the Ministry of Women and the Department of Rural Development and Agriculture and Rural Development? I think these are the core issues that we need to actually start talking about. How do we implement that policy correctly? And is the policy looking at the causal variables properly? Because 10 years from now, we'll be sitting here discussing exactly the same thing. And I'm running out of time. Thank you very much.
Is it still morning or afternoon? Program director, to my moderator, commissioners that are in the room from the Human Rights Commission, thank you very much for this conference. And to my colleagues in the room, ladies and gentlemen, thank you very much. As already mentioned, my name is Nomfundo Ntloko. I am the Chief Land Claims Commissioner. The land question is such a complex one, and you know, I'm sitting from morning listening to the discussions and my head is going at 100 kilometers per whatever. I don't even know where to start because the issues are so complex. They're simple but complex. And I think I'm privileged that I don't have to go into the history because the previous panel earlier spoke about that, including the international perspective. And also my colleagues here seated also gave a nice background. I have a presentation that I prepared, but I'm not necessarily going to go into the presentation. I don't know whether you have the presentation, but I will share it. The beauty is that I know that most of the people in the room already know quite a lot around land reform in general. So I'm going to try and respond to some of the issues that have been raised. Land reform is an indignity that was perpetuated on the people of South Africa. And it's an issue that government continues to grapple with, and one that we as a country need to find a solution to. We say this 30 years on, post-1994. And so I think that it is important for us to reflect on the history, reflect on what we've been able to do until now, and also answer that question that the Human Rights Commission is asking, what do we need to do in order for us to be able to move forward in a way that is comprehensive and perhaps sustainable. And so my focus is on restitution, which is legislated, comes from Section 25(7) of the Constitution, and really forces us to deal with dispossession that happened after 1913. I know that there's a lot of debate around whether it should have been the 1913 cut-off date should have been one that was considered or not, but currently as legislated, that is our obligation. And as a commission, our function really is to receive, investigate, and resolve claims either through negotiation, mediation, and when we are not able to do so, to refer that matter to the Land Claims Court for adjudication. I'm saying this specifically because there is some gray area between the relationship of the Commission versus that of the Department of Agriculture, Rural Development and Land Reform. And so very often we get swallowed into the department, or we get seen as part of the department. But in terms of the Act, we're very clearly a commission that is supposed to operate independently of the department. We operate to implement restitution in terms of Section 25(7) of the Commission, of the Constitution. But importantly, the Minister of Dalrat, as we call it, is the one who is responsible to ensure that the land that is acquired, once the Commission has identified that the claim that was lodged is valid, should then make sure that that gets implemented. But very often that sort of differentiation between the role of the Commission and the role of government is not taken into consideration. So as a result, the Commission finds itself being the investigator, the implementer, the mediator, the adjudicator, and everything else, because as you know, I will receive a phone call from one of you to tell me that a CPA in the Northwest is fighting and they received their land in 2002, and Commissioner, you must come and solve the problem. And so you have to then, in that spectrum, ask yourself, where do various stakeholders come into play in that instance, as opposed to the role of the Commission? Summarily, just to say that over the years, well, since inception, we've probably acquired over 3.8 million hectares of land, and a total award in terms of the expenditure of the state on the restitution program is over 53 billion. I just want to let that sit in. 53 billion. This is around us acquiring land for those people who were dispossessed and who lodged claims, and also refers to us paying financial compensation to those communities who've opted for financial compensation. We've been investigated, researched, analyzed, as you're aware from the previous speakers, and we have done our best to try and deal with the issues that were at hand, whether it was talking to our business processes that were not favorable, whether we're talking about our settlement models, whether we're talking about our capability to conduct research, our staff capability and all of that. We've looked at those things, and we've got a project that we call Project Guyasa, which has been trying to resolve those issues. So I'm trying to summarize because I want to focus on the question of whether we should tackle or amend or review Section 25 of the Constitution. So in effect, the presentation that I've given, and maybe if you go onto our website, will tell you that we've done a business case, we've reviewed our structure, we know our challenges, and you know our challenges, but one key one is out of the budget, and we continue to say that if you don't give us enough money, we're not able to do what we're supposed to do. We have a backlog reduction strategy, which is a 5-year strategy, which we could implement to finish the old order claims in a period of 5 years. But we say that if we're going to be able to do that, if you look at the warm bodies, you look at research and everything else that would need to do, and the settlement, acquisition, the purchasing of the land and paying financial compensation, we would need about 67 billion over that time. I know that National Treasury is going to say that they don't have that money, which then means that if we are left currently with about 6,000 plus claims, which tells you that close to 90% of the claims, old order claims, the Commission has settled, contrary to the perception that we have not dealt with most of the claims. We've dealt with most of the claims. And so we're left with the 6,000, but we look at the complexity of those claims and we say, if we're not given the money, it's going to take us around 30 years to deal with those claims, because you have to go and look at our baseline, which is how many claims we settle a year. Let me move quickly before I get sent away. Section 25. Section 25 has all of those principles, but the focus would be maybe Section 25.3, which talks around on the issue of expropriation. Question that we get asked, why have we not expropriated? We actually have expropriated. But you must understand that in order for you to expropriate, you have to use the existing legislation. Expropriation Act of 1975, we're all aware of it, and that is the current existing legislation. Section 42E of the Restitution Act provides the Commission an opportunity to expropriate land for the benefit of claims that are valid. But in order for you to be able to do that, you need to expropriate with compensation. You don't expropriate without compensation. And so that is where the issue lies. So if you are going to take a property that is owned by a farmer who refuses to give you the farm through a negotiated process, you have to expropriate. How do you do it? You have to look at Section 42E of the Restitution Act. You have to look at PAJA, which is the Administrative of Justice Act. We all know that one. because still the party has a right to be heard, even though you're expropriating. And if you look at then the Expropriation Act of 1975, it talks to the market value, and it also talks to a solatium. And unfortunately, if you look at the history of expropriation that has happened over time, perhaps you look at Benil and other Benil case, a land claim in the Northern Cape, and other land reform claims where expropriation happened. Unfortunately, historically, the market value was used as a basis, and the people who conduct valuations use the market value as a basis. They don't refer back to Section 25.3 and the 5 principles that deal with just and equitable compensation in terms of expropriation. So immediately you try and deal with expropriation, not dealing with the market value, you end up in court, because the landowners are going to challenge you on the issue of market value. And if you look at who does valuations, they've got a formal body, and what is the basis of valuations by the formal body? It's market value. And to add on to the issue of the 1975 Act, government in the past used to also pay a solatium, as in, I'm sorry, we're moving you. So we've had instances in the past where government has had to expropriate using the market value and paying solatium. And so in that instance, if you're dealing with landowners currently who are not prepared to understand the nature of restitution and the spirit of restitution, they argue and negotiate for every cent. And so you have to then understand that even in the context of Section 25.3 of the Constitution, which does allow us room for expropriation, it still says expropriation with compensation, and then we've got pushback on the question of what is just and equitable, and when one can expropriate. So I think that even as we have these discussions, we have to look at those scenarios, and yes, there's a new expropriation bill that seeks to address some of those issues. But those are the challenges. So even if I wanted to expropriate as a commissioner tomorrow, it'll take me twice as long to settle that expropriation claim than a normal mediated claim, because the matter is going to end up in court, and we don't know how the court is going to make a determination. The last judgment that sort of led us slowly in the right direction is the Muloto matter. And that one was where the landowners are challenging the Property Valuation Act of 2014, where the Valuer General was introduced by the state as the only entity that will value property for land reform purposes. They don't like it because it does not talk to market value. It talks to the 5 principles, the historic, how you acquired the land, and all of those things. And so while we are disaggregated in our approach, and we talk about land reform in various pockets, whether it's private discussions, NPOs, and so forth, the landowners have a systematic approach. For example, when we are about to deal with the question of just and equitable compensation on a specific case, if they know that likelihood that they might lose the case, they settle the case. Because at the end of the day, they don't want us to go and deal with the question of just and equitable compensation in court. So there are so many issues that I can speak to. I wish I had a lot of time, but I don't. The last issue I'd like to speak to is, yes, I'd like us to just quickly talk about the reality of restitution on the ground. Things that we never talk about, the fact that restitution has become the face of land reform by default, because everybody seems to know restitution and does not know land reform necessarily. And so the pushback, the anger, and everything else is directed at officials that work in the commission. The pace of settling claims is directed at the people that work in the commission, whereas we rely on the budget that gets given to us. And if you look at the assessment, over the 5 or 10 years, we've spent our budget. But that then should tell you that there's something with how the policy is formulated and how budget is allocated. To the extent that I would like, for the commission is asking the question, how do we help? There has to be a closer working relationship between civil society, the Chapter 9 institutions, and government, not just the Department of Agriculture, all government, because in restitution we don't deal with agriculture only. Tourism, mining, everything else. And as long as we continue to work in a silo where I focus on my aspect and ignore the other, we're not going to succeed. And I say that the Human Rights Commission, as a commission that is supposed to enforce the Bill of Rights and understands that the land question is at the core of the challenges that we have in South Africa, and that if we do not deal with the land question, we cannot say as a country we are able to move forward to a society that is cohesive and that is able to say that we are able to move towards equality. Therefore, the Human Rights Commission and other Chapter 9 institutions should be at the center of dealing with the land question and looking at it holistically from the rural space to the peri-urban and the urban space, and understanding the variants that occur in that space. But also make sure that the institutions that are there are capacitated to be able to carry out the mandate, because for as long as we talk and don't analyze what is actually happening on the ground and understand that the communities who were dispossessed in 1975, when they come to us as the commission, they still have the same pain that they had in 1975. And who becomes or bears the brunt of those communities? It's the commission. It's the project officers who work, who have to be accompanied by police when they go to on the ground, who are shot at, who are abused. Why? Because all of us as government have not taken responsibility to ensure that we've got a cohesive approach to land reform. Thank you very much.
I think you will agree with me, colleagues, that it's always wonderful to listen to people who are really experts in their field. And I certainly have learnt quite a lot. We are running seriously short of time, and I didn't feel it was appropriate to stop our speakers because they was, the inputs were really so rich. I am sure that by doing so, I have allowed you to be enlightened and that you have less questions as a result. But we have promised you a question and answer session. We are at 12:58, colleagues. As you indicate to me your appetite to ask questions, and you should do so now by raising your hands, I want to just assume that given a few things, that we have given the speakers a lot of time to make their inputs. Secondly, that we are going to be here for 2 days, and we are now going for lunch where we can interact on a one-to-one basis if you do have issues that you want to engage on. All of these should satisfy ourselves in terms of our questions and so on, and comments that we want to make. But please, let me see. I see one indication, 2, 3. 3, 1. Oh, no. In which case, I'm going to have to curtail the numbers that we're going to take at this point in time. I know that we're dealing with 2 sessions, but we equally have to go for lunch at a particular time and come back at a particular time, yes. What I suggest you do, let me just see all of your hands again. Okay, I have 8 people wanting to ask questions. I am going to then ask you, please, as you come and pose your questions, I don't want comments. I will interrupt you if you are going to comment. I want you to put your question, 1 question each, because remember, we need to enable people to respond as well. We will have further opportunities, colleagues, to engage. Please make your way up to the microphone, which is here in the middle, and please, people, queue. I do not want to see more than the number of people I have recognized. Yes. Please go ahead, sir.
Good afternoon. My name is Monges Tom from Contralesa, an NEC member. But I was having two clarity-seeking questions and one question, but you said you wanted one question. But I respect that. Let me just pose the question straight. As Contralesa come the presentation from the human rights and all the commissioners that we spoke before us, my question is, how does the international laws relate or collaborate with the institutional traditional leaders, Contralesa?
Maybe you could just, maybe you could just indicate whether your question relates to session 1 and 2, and if you can remember who specifically, so that, you know, I assume that you are referring to Dr. van den Berg.
Yes, that's correct. My question is, how does the international laws relate and collaborate with the institutional traditional leaders, Contralesa, as an important stakeholder in land distribution?
Thank you so much. Thank you. Likewise, if you could indicate who your question is addressed to.
Thank you, Deputy Commissioner. My name is Commissioner Mkolomba from the Public Service Commission, where I am Deputy Chairperson. And my question is to this first session to Ms. Nolundi Luana. In terms of agenda setting for land reform, particularly in relation to the interpretation of Section 25 of the Constitution when it has to do with expropriation without compensation, where is agenda setting in civil society organizations located, bearing in mind that funding comes from outside and externally? So it's a question about locality, positionality, and agenda setting when it comes to land reform. Thank you very much.
Thank you, Tim Hodgson, Senior Legal Advisor at the International Commission of Jurists. My question is for Mpho, but for everyone else also. Mpho raised, from Ndvuno Kwazi raised the issue about urbanization and urban land reform, and then we've proceeded to talk mostly about things that are not in urban contexts. And so the question is generally, how does it impact the presentations made by the speakers, the fact that we're more and more looking at a context where people are looking for land in the cities and not looking for land in the rural areas where they might have been displaced from or to?
I'm going to allocate that question, if you don't mind, because I can't have everybody responding to it. So, Cameron, would you like to take that one? Thank you. Cameron will take it.
Thank you very much. My name is Johannes Nkitsi Mkwena. I'm the president of Watts Forum's Workers, Occupiers, Tenants, Dwellers Forum. My question is on the second session from two people. One from the Department of Rural Development and the Commissioner. One question is that why is this CPA is so much deteriorating to a mess? We see land invasion from those CPA, and they are not being monitored properly, and they are not trained. And then the other one is from the gentleman on the right now facing me. Why is this beneficiaries process, is it deteriorating to a mess as well? Whereby we see on the ground the beneficiaries, when the advertisement is made on the land, it is excluding the labor tenants who are not learned, who are not having resources to can access that information. They only have a surprise as they see somebody placed at that farm being a beneficiary. And we see more fights emanating from there. We have one example from
Okay, thank you.
Okay.
You've posed your questions. Thank you.
Thank you very much. The name is Aubrey Sidupane. I'm a legal consultant by profession. I'm mainly interested in the Land Commission. we are dealing with an aspect of trying to balance Section 25(1), the arbitrary aspect, vis-a-vis land reform. My key question is then relates to the aspect of 25(3), all those enumerated aspects of consideration. Have we conducted an audit around the acquisition of land? In other words, have we satisfied ourselves as to how land was acquired, when and how, so that then we can be able to come up to a particular determination to say, in dealing with the aspect of land reform, so as to ensure that we are not arbitrary and we are not prejudicial as well to the state. How do we strike that particular balance more specifically around the issue of the market value? Because if you have really conducted an audit around the question of acquisition as to how people acquired land during that particular time, we'll then be able to strike that particular balance.
Thank you.
Between, yeah, thank you. Thanks.
Thank you so much.
My questions are directed to Mr. Ndove. I just wanted to find out how much of that land you say was distributed was rural land and how much was distribution of urban land. And then the second question is, are there any plans to audit the remainder of the land, which is 59% of our land, which lies within trusts? Thanks.
Thank you very much. Thank you for your cooperation, everybody. I'm going to hand over to, let me ask the panelists who are already on the platform to respond first. And as you have completed, you may exit the platform. And as they do so, if the other panelists from the first session can take their place on the platform to respond in turn to their questions. Shall we start with you?
Thank you so much. I was not expecting difficult questions, but unfortunately, they are. I'll be sharing this with my colleague here. I'll deal with the issues related to a beneficiary selection, a particular focus on the exclusion of labor tenants that creates problems. Let me indicate that when the advert goes out, it does not exclude any person. I'm talking about those who qualify, and labor tenants are not excluded. Well, I will not know that in practice, because of other limitations, maybe labor tenants don't find an opportunity to have information. Maybe that's something that we can work on, so that they are also participating like any other person. But in practice, they are not excluded. So there's no exclusion for them. And they are, and because, remember, in terms of labor tenants, there are labor tenants who have got other forms of livelihood, not necessarily interested in managing, or farming in the large scale. Obviously, you can't get a farm that is properly functioning and hand it over to a person, and I'm not talking about labor tenants, any other person who does not have experience to manage such. Otherwise, we are going also for another problem, unless they are properly assisted, trained, not only for labor tenants, any other person. So in conclusion, I'll say they are not excluded, and in case there are some challenges, specific challenges, I'll be around here. Please talk to me so that we can just deal with if there are specific challenges. But in practice, they are not excluded. And there are labor tenants who are actual farmers as we speak. The next one is about the land. Let me indicate that the land that I've indicated here, in the main, and I want to make it very clear, in the main is what you can call agricultural land. And obviously agricultural land is in the rural space if we talk about outside the urban area, not in terms of communal or whatever, but in terms of it's on the rural space. So most of the land that we're talking about I can even say without any contradiction that almost all the land that are involved in land redistribution and tenure, because if we secure tenure rights of people that are in farms, obviously it will have to be settled somewhere in the farm. The same applies to land for agricultural purposes to be in the farm. However, there is land that has been allocated for urban setting, especially peri-urban commonages. We have bought land for commonages, which is mostly in the urban setting. Of course, we do not account for it in terms of the statistics, but that's an information that we can be able to know. But I just want to indicate that in our approach, we, as land reform, it's land reform that is inclusive of both land for agricultural purposes, residential, and any other purposes, peri-urban, and as well as at urban centers. So it includes everything. But I'm just indicating that the majority of the land that we have seen, in the main, obviously, it will be in the rural space. In terms of the audit, yes, that is an area that we also worried about, but let me just indicate what are the challenges. And it's a challenge that we should all face. Trust. You know the trust and how trust have been used. So it is not used for all, it is not only used for other purposes to hide money or whatever, they also use it to hide land. Are we together? So it means you have to break up a trust in order to see who is in the trust. Obviously, we are in a country that has got legislations. I'm not sure what does that mean, but it's an area that needs to be faced by this country because, and without discriminating anyone, we even have people who were not supposed to get land in this country, who are getting land through this kind of structures. And that poses a serious challenge for the country. I think I should stop there.
Thank you very much. We've been told that we must minimize our responses. I just wanted to say that with regard to the issue of the CPAs, I think that I would like to align myself with Nolundi Luaya's proposition on the second intervention that she made, that all of these issues are really around post-settlement support, development, the use of the land, mediation when CPAs and trusts fight. So if we can collaborate and find a solution outside of just focusing on the legislation, perhaps we should be able to then deal with those issues. On the question by Aubrey on Section 25.1 and the interface between Section 25.3, I think the important thing that we need to remember there is that the Property Valuation Act of 2014 was introduced specifically to deal with that question of just and equitable compensation. And Section 12 of the Property Valuation Act speaks to the fact that only the Valuer General has the authority to value land that is going to be used for land reform purposes. And in order for the values to be conducted, the 5 principles have to be taken into consideration. So all of those, including the history of acquisition, and all those principles are taken into consideration, which is why I said that we need to look at the Property Valuation Act much closer, because that is enabling legislation that could potentially solve the problem. But there's a lot of pushback in terms of the regulations that the Valuer General has put in place, and whether people agree with the formulas that they've applied in interfacing with what Section 25.3 seeks to achieve when it deals with just and equitable compensation. Thank you.
Hi, thank you for that question. And very briefly, just a question around sort of urban versus rural land reform right now. I think it's actually a difficult question. So it's something that Cheryl Walker speaks about. She speaks about the sort of master narrative. That is a sort of this political fable that sees sort of has this incredible focus on rural dispossession only. And And I think, and that has been a problem in terms of how land claims have actually been settled and finalized. When you look at the statistics, perhaps, and correct me if I'm wrong here, but I don't think I'm slightly off. When you look at urban land claims, the majority of the 79,000 claims I think have been urban, and the complex claims have been rural. But 80% of those urban claims have actually been settled by the settlement offer, right before the Florence judgment. I think it was 2011. So it was the standard settlement offer, which was like 40,000, 60,000 and upwards. And then after the 2011 Florence judgment, I think you looked at sort of compensation in terms of the particular formula. So the problem with that actually arose is that you did the injustice there to a certain extent, but the focus of mass processing of urban claims is that you actually had an opportunity, provided obviously that the restoration was feasible, to actually correct the apartheid spatial planning. Because people would have been turned to the land that they lost, which would have been informally white areas, right? But we missed that opportunity. And I think that is a bit of an indictment. I suppose we can't do much about that now. But I think that we need to correct the paradigm. Section 25 does sort of focus, and this whole focus is on rural dispossession. But I think that one of the things that we need to do is we need to correct the paradigm. Clearly, there's a serious challenge sort of in the urban space, and there's a need for urban land reform. So how do we make use of sort of the land owned by the state to facilitate proper urban land reform? I think that is key. The Public Service Commission at the moment is going to embark on a sort of a multi-sectoral sort of engagement with particular parties, including the Commission on Land Restitution and the Department of Rural Development and Agriculture. And maybe we just need to consider sort of other stakeholders to look at the broader challenge around urban land reform. Thank you.
All right, regarding the interrelation between traditional laws and international law, while human rights are universal, interrelated, interdependent, so human rights certainly are of relevance in traditional laws, and for those who live under customary and traditional laws as rights holders. Now, of course, traditional leaders are a bit of a different question because they are both rights holders vis-a-vis the state and business activities, so forth, but they are also duty bearers vis-a-vis the people who they serve. And as a duty bearer then, both the state and traditional leaders would have the duty of non-discrimination and equality. So the state, in recognizing traditional leadership, traditional law, in terms of the Now Act and so forth, has that duty not to discriminate, to ensure the meaningful participation of the stakeholders. And then in turn, traditional leaders have a duty not to discriminate and to, develop the traditional laws where it does result in discrimination, for example, against women. So there are both those facets in that relationship. In terms of marginalized groups, there's definitely international law. The human rights principle of participation means that people living under customary law, traditional leaders, need to be able to participate and have a voice at the table in terms of international developments as well. In terms of access to justice, traditional leaders as well as people living according to customary law are rights holders and have a right to access justice and can also make use of these international law mechanisms, such as the special procedures, so the special rapporteurs. And we saw, for example, one of the comments was by the Committee on the Elimination of Racial Discrimination. So in terms of the International Covenant on the Elimination of Racial Discrimination, that committee will have a very strong interest in ensuring that traditional laws are respected and that people affected by them are given the opportunity to meaningfully participate, both in terms of other laws and those laws as they are applied. So in a nutshell, I believe there is a close relation, and that it's not one of conflict. It really is, at the end of the day, to ensure that rights holders get their justice through claiming their rights, and that duty bearers discharge their obligations also in respect of land. Thank you.
The final question was mine, and my thanks to Commissioner Mkolomba for her question, which was about where is the agenda setting for land reform taking place, especially in light of where civil society organizations receive their funding from. It's a critical question, and I think part of a larger conversation, and I'll answer it briefly in two ways. The first is to speak specifically about my organization. In recognition of the fact that positionality matters, and we are an urban-based, well-resourced organization, we take an active approach to trying to make sure that the agenda setting is led by the communities themselves. So they are the ones who need to make the determinations around what policy they think works for them, what legislative interventions they support or don't support. I'm the first to admit we don't always get that balance right, but it is an important balance precisely because of the positionality that we occupy. We also intentionally try to pursue funding from South African sources, although there are a couple of international funders who do support our work, but the majority of our funders are actually South African, and that's on purpose, so that we are being conscious of where it is that our funding is derived from. But of course, there's always the fact that, of course, sources of funding are not really ever local, right? They always are somewhat influenced by international trends. In terms of from a sector perspective, I'd say there is no singular point where agenda setting is happening at the moment. So unlike in the late 80s, early 90s, where one might have had a more unified approach to agenda setting through something like the NLC, there is a far more sort of decentralized agenda setting. Most organizations are trying to be conscious of positionality and are therefore actively trying to make sure that the agenda setting is led by communities and those who are directly affected.
Thank you so very much to everybody. As you walk down, be careful. Thank you so much. Ladies and gentlemen, we have gotten to lunch at this point. I want to ask you please to, reason being we have a speaker at 2 who cannot stay beyond the time that we have given her. So we absolutely have to start the next session after lunch at 2 o'clock, after which, of course, we'll be a little more relaxed for time and we'll not try and beat the clock the whole time. And there will, as I say, over the next 2 days be an opportunity for you to engage during breaks, tea, lunch, etc. So please take advantage of the lunch, and thank you all so very much for participating in this session.
Ladies and gentlemen, just a quick announcement. For lunch, we are going to Clover's Green. So when we exit the venue, we will turn left and we will go straight into Clover's Green on that other side. So please take note. Oh, I would suggest that you really take your personal belongings for safety measures, please. Yeah, thanks.
I need to actually get my pack. Let me.
Wait October. I'm so proud of you. November. October.
Well done. Well done. From Friday, starting with the roadshow,
Ladies and gentlemen, welcome back. I must say we have done very well with time. And now we are ready to proceed with our program. And I'm glad to see that we've got more representatives from the House of Traditional Leadership who has joined us today. Although we were expecting them we're expecting them tomorrow, but they are most welcome. Ladies and gentlemen, we are now getting into another session where we will be receiving our keynote address from Dr. Geraldine Fraser-Moleketi. But Dr. Geraldine will be introduced by our chairperson, Advocate Majola, who will then lead us into the next session. Thank you so much. Over to you.
Ladies and gentlemen, it's my great pleasure to introduce Dr. Moleketi, the Chancellor of the Nelson Mandela University. Some of her early achievements include working on the preparation of the African National Congress for its first democratic election in 1994 as National Deputy Elections Coordinator of the ANC. She previously served in the leadership of the ANC and the South African Communist Party. She served as member of the South African Parliament for 3 consecutive parliaments, which is 1994 through to September 2008 when she resigned from Parliament. She served in the South African government as Deputy Minister of Welfare and Population Development, thereafter as Minister for Welfare and Population Development. Subsequently, she was appointed as Minister of Public Service and Administration for 2 consecutive terms until her resignation in September 2008. During her tenure as Public Service Minister, she served as Chair of the Pan-African Ministers of Public Service for 3 consecutive terms. In addition, she was appointed as at a global level to the United Nations Committee of Experts in Public Administration, a subsidiary expert body of the UN Economic and Social Council. She served on the Commonwealth Association of Public Administration and Management Board. She was a member of the advisory board of the Institute for the Study of International Development, McGill University, Canada, and served on the Africa Advisory Board of Women's World Banking until December 2018. Dr. Fraser-Moleketi was the former Global Director of the United Nations Development Programme, Democratic Governance Group, until the end of August 2013. Thereafter, she joined the African Development Bank as Special Envoy on the Gender at the level of the Vice President until 1st January 2017. She served on various boards across academia. She is the Chancellor to the Nelson Mandela University, Chairperson of the Advisory Council of the Mapungubwe Institute for Strategic Reflection, MISTRA. She has been reappointed and serves as Chairperson to the Committee of Experts in Public Administration by the United Nations Secretary General for the period 2018 to 2021. Dr. Moleketi was named 2016 New African Woman of the Year, an award made by London-based magazine New African. She is a non-executive board member of the Standard Bank Group, Standard Bank South Africa, and lead independent director of Exaro. She was appointed chairperson of Tiger Brands with effect from January 2021. It is my greatest pleasure to welcome you, Dr. Moleketi, and also to present you to the audience that is waiting with bated breath.
Thank you, Chairperson.
Sure. Thank you very much for that introduction, Chairperson. I'm going to vet the clips people read when introducing, because I think it almost takes the place of a keynote, you know, if we're not careful. Can you just help me, or I'll take this out? Yeah. I think I should take it out. As you can see, I am not the tallest person in the room. Good afternoon, everyone. Program Director, Chairperson, Professor Bongani Majola, Deputy Chairperson, Ms. Fatima Chouan, and then I'm just going to say commissioners who are present here and those who may be on virtually, to the CEO, Mr. Vusumzi Kize. I reminded him that he's got a very important surname, and I know there's many people here who have been involved in the whole land, the whole issue of people being removed from land and the movements around there. And we celebrate those who have come before us. And one name that we associate with that whole issue is Solum Kize. We also will acknowledge Mambuti Mkize in the process as well. And we think of Driefontein and Mpumalanga because there were major land struggles that were fought in different parts of the country. And we sometimes allow this to recede into our distant memory. I want to recognize all senior public servants and public officials of the various spheres of government that are attending. And it seems as though the acting public protector seems to be stalking me if I look at activities over the past few days. Not a bad stalker, though. And that's so distinguished guests from the public and private sectors, and above all, those from civil society. I've spoken about those who are joining us on live stream. And if you permit me, because I'm not in public office, I can say comrades and friends. Those of you who are in public office may be may have a bit of a constraint around that, but I don't. That's being, I think, liberated in some ways, did it to myself as well. So I'm deeply honored to be invited to deliver the keynote address by this, at this very important conference convened by the South African Human Rights Commission. The land question and its associated issues are matters that are very close to my heart, because we all have a story to tell. And it's not for today, but watch that land that Cape Town Airport is on. That belonged to those who came before me in the family. I'm not going to submit a claim. I think other family members will do it. So I'm not going to bring that problem to you. But I'd really want to begin by congratulating the South African Human Rights Commission for your boldness in organizing this conference at this juncture in our nation's history. As a Chapter 9 institution, you are indeed striving to fulfill your homework. So in the time available to me, and I'm going to take liberty, I was told, Chair, that this is an hour long, so I hope it's okay. But I'd like to explore 3 salient points relevant to our deliberations here. Firstly, Has South Africa fully reckoned with the effects of the Native Land Act? Secondly, from an assessment of key legislation enacted since 1994 by the high-level panel on the assessment of key legislation, does South Africa need a reimagination of Section 25 of the Constitution, especially 25(7)? And thirdly, what does reimagining look like, and who must play a role in crafting the reimagination of Section 25? Now, the Deputy Chair of the Commission was so kind to take me through what had transpired this morning, because I was at another commitment with another key institution in the public sector and was unable to join you. Not because I thought I was too important, it's just there were competing commitments. And she advised that the people in the room have a depth of understanding of the issues we're dealing with. So you'll bear with me if I'm being repetitive around certain issues that you've raised. So the role of a keynote is to set the scene and to make a contribution to the debate and also to challenge. I will therefore end my address with somewhat provocative questions on different aspects of the issues the conference has been grappling with and will be grappling with. So, on the impact and effects of the 1913 Land Act, I've said earlier this conference is timed to mark the 110th year of the introduction of that 1913 Land Act. Simply put, that Land Act dispossessed the majority of black South Africans and took away their rights to own or rent land outside of the reserves that initially made up only 7% of the land. At the time, Saul Plaatje movingly recorded, and I quote, "Awakening on Friday morning, June 20, 1913, the South African native found himself not actually a slave, but a pariah in the land of his birth," close quote. Tembeka Ngukatobi correctly points out, and I quote, that the 1913 Native Lands Act was the most visible manifestation of colonial conquest as it formalized dispossession. Notwithstanding the many gains that have been made since the advent of democracy in 1994 in South Africa, we remain one of the most, if not the most, unequal society in the world when measured by the Gini coefficient. Millions of South Africans wake up every morning to the triple challenges of poverty, inequality, and unemployment. That's the harsh reality on the ground. It has been argued, and I think correctly so, that a direct line can be drawn between the impact of the 1913 Land Act and poverty, inequality, and unemployment in South Africa today. That is not to say, or it doesn't mean, that it is the only contributing factor, but like a major river with lots of tributaries, it runs through our history to the present. Now, I don't subscribe to the narratives that sketch only doom and gloom for the country narratives that will make us believe that absolutely nothing has been achieved since 1994. But I also believe that we need to soberly reflect on the progress or lack of progress that's been made in addressing the land question. Whether or not we have met our constitutional obligations, and whether the state indeed has the capacity to do so, and what the possible solutions could be. The 1913 Land Act struck at the core of the livelihoods of African people and rendered them destitute for generations. The impact was so profound because it locked black people into meager forms of subsistence and formed them on the labor market, placed them on the labor market at menial wages on white-owned farms and mines. Of course, the impact was not only a physical one. The loss of land and livelihoods also impacted negatively on the soul and spirit of generations of people. And hence, Deputy Chair, I was very touched when you spoke about Shine, I think it is, because it's about dealing with this trauma that's embedded in our DNA that we take for granted. But look, trauma is not only negative. The resilience of coming through is positive, but we need to do something about that. It's difficult to overstate the impact the 1913 Land Act had on the lives of millions and millions of Africans. Let me repeat, and I said this earlier, at the stroke of a pen, they were deprived of their livelihoods and forced onto the labor market at starvation wages. As segregationists, and from 1948, apartheid legislation became entrenched, these small pockets of land to which the majority of the population were confined became increasingly overpopulated and overgrazed pieces of land. And as the madness of apartheid grew, these pockets became the basis of the Bantustans and homeland policies of Grand Apartheid. The 1913 Land Act became one of the central rallying points for resistance to segregation and apartheid by generations of activists. And I will cite just two examples. The 1943 African Claims response to the Atlantic Charter demanded inter alia, and I quote, freedom of residence and the repeal of laws such as the Natives Urban Areas Act, Native Land Act, and the Native Laws Amendment Act that restrict this freedom, close quotes. Secondly, the Freedom Charter was very specific in this regard. And on the land issue, in particular, it demanded the land shall be shared among those who work it. Restrictions of land ownership on racial basis shall be ended, and all the land redivided amongst those who work it to banish famine and land hunger. The state shall help the peasants with implements, seeds, tractors, and dams to save the soil and assist the tillers. Freedom of movement shall be guaranteed to all who work on the land, and all shall have the right to occupy the land wherever they choose. People shall not be robbed of their cattle, and forced labor and farm prisons shall be abolished, close quotes. Those in the liberation movement involved in negotiating the transition to democracy. And the framers of our constitution were very conscious of the deep negative impact of the 1913 Land Act and similar pieces of legislation. That is why Section 25(7) of the Constitution affirms that, and I quote, "A person of community dispossessed of property after 19 June 2013 as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an Act of Parliament, either to restitution of that property or to equitable redress," close quotes. This, of course, raises a number of questions. Not least of these is why, if opposition to the 1913 Land Act was such a core part of resistance to segregation and apartheid, and if restitution and redress are entrenched in our Constitution, why are its effects still with us today? To begin to answer this question, and I'm sure you've dealt with it earlier in the day, we need to explore the measures taken to address and redress the effects of the Land Act and associate legislation in a bit more detail, so that we understand the context of the Section 2025 debate. With the advent of democracy in 1994, the democratic government designed a number of pieces of legislation to remedy the effects of the Act and to give effects to the undertaking around land and land reform as set out in the 1996 Constitution, which I've already cited. However, as many have argued, and one now finds a groundswell of these voices, these efforts have been met with checkered success. The fact that 2023 is the 110th anniversary of the 1913 Land Act is a painful reminder to younger generations especially of this lack of progress. And this has ignited the determination to make the land reform undertaking happen in practice. The legislation and policy approach to addressing the challenge since 1994 has been to divide land reform into three parts: restitution, redistribution, and 10-year land reform. Each part has been fleshed out by legislation that aims to bring South Africa closer to its goal of land reform. So the first part, restitution, is addressed in Section 25(7). I'm not going to go into it because I assume you've dealt with the debate, and I will make my notes available if you would like to have a look at it. So the Commission of Restitution of Land Rights were constituted in 1995 to hear land claims. The Commission of Restitution of Land Rights. And at 1999, although 37,531 claims had been submitted, only 785 claims had been settled at the cost of 78 million rands. The submission date for land claims has, however, been extended several times. And there's a lot else around the Amendment Act that was declared unconstitutional in the land access movement of South Africa versus Chairperson, National Council of Provinces in 2016, because there was no public participation and consultation. The new submission date was not rejected by the court, and these claims may still be processed. That said, this may well lead to further delays in processing of older and newer claims, and given the fairly onerous procedures entailed in doing so. But I believe earlier today you spoke about, shall I call it the infrastructure that needs to take this forward. The next section is redistribution. I'm going to treat it in a similar way, that there's been a debate around it and its meaning and its goal to redistribute land back to those who do not have land or do not have adequate access to land, and I won't unpack that. To aid the process, the Land Reform Labour Tenants Act of 1996 was passed and provided that a labour tenant could apply for the acquisition of their leased land before their eviction, and went on to provide that tenants could only be lawfully evicted. The Settlement Land Acquisition Grant SLAG was the main distribution method to 1999, and under SLAG the state would provide a subsidy of the equivalent of 16,000 Rand for the purpose of land acquisition and further security of tenure. However, this amount was too minuscule for many South Africans to purchase back their land, especially with the increase in land prices. So many people pulled their grants together to buy land. This led to overcrowding on the land purchased and a less productive use of the land as a result. The SLAG program ended in 2000, and subsequently the government introduced the land redistribution for agricultural development in 2001. This program was different from SLAG because the applicants did not have to be poor in order to receive a grant. LRAD was also different because applicants could receive a more substantial grant depending on how much they contributed in terms of money or labour. The third pillar of land reform is land tenure, and is intended to provide tenure security for those living on land owned by another person or on communal land. The Land Reform Labour Tenants Act and ESTA are laws that protect South Africans from being unlawfully evicted. The Land Reform, in brackets Labour Tenants Act, provide that a tenant cannot be evicted except if a decision is made by the Land Claims Court. Again, I'm going to treat the elaboration in my intervention as having been covered in the discussions that were all held earlier. In 2002, the Draft Communal Land Rights Act was published and passed into law by President Thabo Mbeki in 2004. This act would make security of tenure legal in South Africa for efficient utilization for about 1/3 of South Africa's population. However, many contend that this legislation has been unsuccessful due to the inflating of prices of land, the failure of the willing buyer, willing seller method, and the move towards a more urban lifestyle by many black South Africans. The willing seller, willing buyer philosophy has been particularly detrimental to the timely transfer of land because it assumed there were willing buyers and sellers and that there would be equal transactions or a win-win amongst those buying and selling in South Africa. However, this has proved to be problematic as it gave farmers leeway to increase prices of land they were willing to sell. And therefore, in the 2013 State of the Nation address, President Zuma promised that government would alter the policy to just and equitable compensation. Here, factors such as the market value of property, the usage of property, the history of property, and the interests of those affected are considered. Overall, government has been criticized for the slow progress of land restitution and for restitution's high cost. Some commentators expressed concern that it could possibly lead to similar results as experienced in Zimbabwe, where strife around land reform resulted in a crippled economy and an estimated 150,000 black workers without jobs. A fairer take, however, is suggested by Cheryl Walker, namely that it is not so much that government has not made progress, but that it set its standards too high, bearing in mind that government had planned to deliver 30% of the land by 2014. The reality is that the 1996 goals remain ambitious, and government continues to make adjustment in the hopes of rectifying the legacy of the 1913 Natives Land Act. I'd now like to turn to the role of the South African Human Rights Commission in land reform and the recommendations of the high-level panel on this assessment of key legislation. Can I have some water, please? The South African Human Rights Commission has engaged with land reform, with the land issue, numerous times in its history, in recognition of the importance of land redistribution and in pursuit of its mandate. The Human Rights Commission has undertaken several interventions to hold government accountable in terms of the constitutional imperatives on the matters of land. From 2001 to 2019, there were several Human Rights Commission reports and findings that serve as milestones along the route that has brought us to the discussion we're having today. The Commission has continuously monitored the issue of land use through public hearings, the resolution of individual complaints and engagement with relevant state departments. Overall, and I cite the Commission itself here, and I quote, "The Commission's findings point to a concerning lackluster state response to land reforms," close quotes. This statement should be a matter of concern for all South Africans who have the nation's well-being at heart. That is what brings us all together here at this conference. Now, I'd like to turn briefly to the report of the high-level panel on the assessment of key legislation and the acceleration of fundamental change of November 2017. The report of the high-level panel on the assessment of key legislation and the acceleration of fundamental change. The panel conducted a full review of post-apartheid legislation to assess the extent to which such legislation and its implementation give effect to the constitutional mandate. The panel addressed three key themes, namely poverty, unemployment, and the inequitable distribution of wealth. Land reform, redistribution, and security of tenure, and social cohesion and nation building. With regard to the three rights of land reform, mentioned above, the progressive realization of these rights is concerning. It found, and I quote, "The pace of land reform has been slow. The development of policy and law has drifted away from the initial pro-poor stance and lacks a vision for an inclusive agrarian reform. There are also significant gaps, such as on tenure security, where legislation has not been passed, putting the lives and livelihoods of many rural dwellers in peril. The government's interpretation of customary law centered on traditional leadership and away from living custom has added to the insecurity," close quotes. After a very detailed and comprehensive analysis, the report recommended a range of high-level but also detailed inputs to the formulation of legislation. Two are of specific relevance to us here. The recommendation includes enacting a new framework law for land reform. It argued that new legislation was needed to provide a coherent framework for the various components of land reform, with a focus on pro-poor redistribution. This is because land reform policy has, and I quote, "drifted from its initial pro-poor focus to one marked by signs of elite capture. Implementation has also been dysfunctional," close quotes. It further stated, and I quote, "To ensure that land reform delivers the constitutional land rights, Parliament should enact framework legislation that addresses the deficiencies of law and policy. No law currently exists to give meaning to or set standards for measuring whether land reform enables citizens to gain access to land on an equitable basis. This law will provide guiding principles and definitions for terms such as equitable access. It also provides for institutional arrangements, requirements for transparency, reporting and accountability, and other measures to ensure good governance of the land reform process," close quotes. The report also recommended amending the Restitution of Land Rights Act of 1994 in order to, and I quote, "address current capacity, resource and accountability constraints before July 2018, close quotes. In its motivation, it argued, open quotes, "the poor outcomes and slow pace of restitution have been confirmed by numerous government reports." So let me now turn to the third salient aspect I said I would cover, the discussion of the amendment of Section 25 of the Constitution. The issue of the necessity for the amendment of Section 25 of the Constitution. Whether or not we amend the Constitution is a matter that requires deep reflection that needs to take a number of factors into account. The high-level panel on the assessment of key legislation and acceleration of fundamental change, after a thorough assessment, made a specific determination in respect of the proposed amendment of Section 25 of the Constitution. And I quote, "The panel is of the view that government has not used the powers it already has to expropriate land for land reform purposes effectively. nor use the provisions in the Constitution that allow for compensation to be below market value in particular circumstances. Rather than recommend the Constitution be changed, the panel recommends that government should use its expropriation powers more boldly in ways that test the meaning of the compensation provisions in Section 25(3), particularly in relation to land that is underutilized or unutilized. The lack of well-situated land for urban settlement remains a stark legacy of apartheid planning and discrimination. Well-situated, state-owned land needs to be made available for housing for the poor, and well-situated, privately owned land targeted for expropriation, close quotes. So having covered the ground, so to speak, around the effects of the Native Land Act and key pieces of legislation enacted since 1994, and having briefly examined the high-level panel on the assessment of key legislation and a possible amendment of Section 25 of the Constitution, I would now like to turn to what I consider crucial aspects in the discussion of the way forward on the land reform. Of course, the land question is an emotive one, and it generated a great deal of political rhetoric. I'm not going to go into a deep analysis of this now, but suffice to say that former President Thabo Mbeki has produced a comprehensive analysis of the rhetoric around the land question and its implications. Instead, I would now like to briefly turn to a number of interrelated questions which I think are crucial as you deliberate on the big questions of this conference. A, have we diagnosed the causes of failures and delays in land reform adequately? I was not here this morning. You may well have done that. B, what's been the cause of the lack of execution and the implementation of the land reform program and the delays to date? C, will an amendment of Section 25 of the Constitution actually result in the land reforms that millions have been waiting for since 1994? And is it necessary? D, whilst we have a good legislative framework in place, do we need an overarching land reform statute to pull the legislative threads together and to address the current constraints? Does the state have the capacity to implement land reform policies and achieve the desired outcome? And related to that, is there sufficient political will to implement what is needed? How do we identify who the real beneficiaries of land reform should be and prevent corruption? How do we give agency on land matters back to the community? What does equitable access really mean? And how can equitable access to land be coupled with empowerment through integrated and coordinated support by relevant government departments? How do we fast-track equitable land reform as a catalyst for economic and social development for the poorest and most vulnerable? In a nutshell, and to return to the topic of my address, how do we shift from political rhetoric and well-researched reports to action on the ground. And as I move towards closing, I want to return to Saul Plaatje. And I want you to picture him on his bicycle, cycling through the Free State, part of the then Transvaal and the Eastern Cape, collecting evidence about the impact of the 1913 Land Act along the dusty country roads, in biting cold and excessive heat. His findings were published in 1960 in the book that I cited at the start of my address, Native Land in South Africa. Hold that image in your head and ask yourself, after 110 years of the effects of the Land Act, isn't it time to put an end to its pernicious effects? I wish you well in your deliberations, because this is when I cut and run, and hope this conference and its outcomes will serve as a clarion call to action for all relevant role players. It's my sincere wish that when historians come to write the history of our country 21 years from now, the 50th anniversary of our democracy, they will point to this conference as a watershed. Perhaps I should say a landmark event that unblocked the blockages of land reform and set our nation on the road to social justice, equality, and prosperity for all. It is in your hands. I thank you. So I'll send a copy of my address, and I think we have one contact person that we will send it to. Yeah, thank you.
Thank you very much, Dr. Malekete, for that beautiful keynote address. If you may allow us, we would like to give you something of, as a thank you gift. Obviously, we would like to declare it to the public. The public protector is here as well. She's watching. So this is just a small token of thank you.
It's not the title deed, so I have to give it. Thank you very much. Thank you. Thank you very much. Okay. Thank you very much, everyone.
Ladies and gentlemen, we are now moving on to our last plenary session, where we will be having key individuals coming from Chapter 9 institutions who will be taking us through with certain themes that are related to how corruption and the impetus that contributed to non-fulfillment of many recommendations with respect to the Chapter 9 institutions, to Section 25 of the Constitution. And they'll also look at what work have Chapter 9 institutions done so far as land issues are concerned. They'll also look at what can Chapter 9 institutions do to ensure that government complies with the obligations of Section 25, subsection 7. And we would like to now call onto the stage Commissioner Jonas Sibanyoni, who will be part of the panel. And we would also like to call Dr. Stan Matodoga, Acting CEO, the Commission for Gender Equality. And we'd also like to call Professor David Luka Musoma, the CRL Commission Chairperson. And we'd like to also call Advocate Kollega Kalega, who's the Acting Public Protector in South Africa. And this session will be moderated by Commissioner Andrea Gorm, who's part of the South African Human Rights Commission. So let me hand over to this plenary, which will take us towards the end of our day today. Thank you. Oh, and sorry, I just forgot one note. I think we will be having Ms. Khoba Komape from the Office of the General Auditor South Africa, who will be joining the panel, if I am correct. Yeah.
Good afternoon to everyone, and it's wonderful for all of us to be here with you today. As already indicated earlier, I'm Andre Gaum, I'm with the South African Human Rights Commission, and we're now at the third plenary on the work of Chapter 9 institutions on land, and as indicated, we look at numerous aspects in this regard, inter alia, the role of Chapter 9s, what work we have done as far as the matter of land is concerned, the extent that recommendations have been acted upon by government, other stakeholders, and the matter as to whether we believe that government complied with its obligations in terms of Section 25(7), and what can we do to ensure that there is indeed compliance. So we are joined by Commissioner Jonas Sibanyoni, Dr. Dennis Matutoka, Professor David Musoma, Advocate Kollega Kalega, and Ms. Gabu Kumape from the Auditor General's Office. And we'll give the first opportunity then to Commissioner Sibanyoni to introduce from the South African Human Rights Commission side and to indicate what the Commission has done thus far with regard to the land issue. And then we will give the other guests an opportunity, after which there will be inputs and comments from the floor and a final round to each of the participants. Commissioner Sibanyoni.
Thank you, Commissioner Gam. Good afternoon. In Sesotho, they say, Madume a feli. In other words, greetings don't end. I would like to say greetings to the moderator of this session, warm greetings to my fellow panelists and colleagues within the Chapter 9 institutions. As stated, my name is Jonas Banyoni, but affectionately known as JB Sibanyoni. Why I'm mentioning this, I want to break the ice for the afternoon session. Many people say the afternoon session after dinner is a graveyard session. So I want us to forget about that. But not only that, I once had an opportunity, I'm not bragging about this, that one time I was called by the late Pius Langa, and who eventually became the Chief Justice of the Constitutional Court, to form part of the 10 members of NADEL to go and see Honorable Nelson Mandela at Victor Verster Prison. As we're introducing each other, the team, I said, they call me JB. And then he said, JB Marx. And then I had an opportunity also later to work at the Union Building. And then after some years, he came there. He surprised me. He was entering each and every office where there are some managers. And then as he stepped in the office, he said, JB Marx, do you still remember me? Then I laughed. I said, Tata, who can forget you? But without any waste of time, I want to acknowledge the contribution by Commissioner Ntuli, Pilile Ntuli, and Commissioner Nissen, who also assisted to put this conference together, and as well as Advocom. Advocom stands for the Advocacy and Communication of Human Rights Commission and the Research Department. Let me talk about the purpose. In this short talk, I will not go through all the work done by the Commission on Land. My focus area is land, farming communities, or the right to food, as well as environment. That would not be of great use and value to this conference if I go into details about that. In essence, I want to pose a challenge for all of you who are participating in this gathering. As the Commission, we issue research briefs, investigative reports. In other instances, we make submissions into parliamentary bills. We also are able, in some circumstances, to approach a court of law in order to protect particular rights or to stop the violation of a right. We also receive complaints and assist complainants either through mediation or referral. This is not an exhaustive list of how we work, but it gives a good idea, because I want to be brief. The Commission has issued a number of reports on violation of human rights and what steps should be taken to protect those rights and to stop violations. These reports contain various findings, directives. I want to emphasize directives, acting public protector, and recommendations. These directives are intended to ensure appropriate redress where human rights have been violated. Some of the reports we have issued at the Human Rights Commission are the following. The report on high-level public inquiry into impact of rural land use and ownership patterns on human rights 2019 report. In that report, the Commission found the following. There are significant problems in conceptions or in the conception and implementation of the land reform program. There is a worrying lack of comprehension and knowledge of the various statutes, government land use, and land tenure by stakeholders responsible for the implementation of such legislation. Land redistribution has been slow when assessed against both its own targets and those of society's expectations, and benefited women much less than men. In cases of successful land claims or land redistribution as part of land reform, post-transfer support has generally been inadequate, in part because of poor coordination among government departments. Some of the recommendations are as follows. The Department of Justice and Constitutional Development should ensure a training program for the police, prosecutors, and magistrates on the interpretation and implementation of ESTA is developed and implemented. Parliament should prioritize ensuring that meaningful legal protection is provided to vulnerable communities faced with external mining or other investment projects that are likely to negatively impact on such communities' land rights. Then there is a report of the Human Rights Commission on the national hearing relating to human rights situation in the Khoisan in South Africa. The Commission recommended, among others, the following. The Department of Rural Development and Land Reform, together with the Office of the Presidency, is required to take steps to expedite the process of restitution for indigenous communities in light of the recognition of the centrality of access to land, traditional territories, and natural resources for the fulfillment of other rights of the Khoisan. The report of the Human Rights Commission investigative report on issues and challenges relating to unregulated artisanal underground and surface mining activities in South Africa. These reports are faced with challenge of compliance. It is this particular issue of non-compliance on which I want to ground my challenge. The Commission's reports are at times ignored and not complied with. At times when the Commission follows up, there is an impression that a particular report will be complied with, and when the Commission follow-ups, we realize it has been ignored. This non-compliance with these reports disables the Commission's power to make an effective and timeless impact in protecting rights. This challenge of non-compliance has now been given legal legitimacy, ladies and gentlemen, through certain judgments that have held that the Human Rights Commission does not have the constitutional and legislative power to make binding directives. This is a seminal challenge for the Human Rights Commission's human rights and financial resources. It also amounts to judicial weakening of the Commission's power to take steps to secure appropriate redress. In a way, this also weakens the Commission's legitimacy as an institution created to support constitutional democracy. One of these judicial pronouncements on the power of the Commission stems from a report issued by the Mpumalanga Provincial Office of the Human Rights, where the Commission issued directives to a farmer. In essence, the report directed that the farmer refrains from stopping occupiers of his land from accessing clean land. The report stated that the farmer must have a meaningful consultative session with those occupiers regarding efficient management of water on the farm. Moreover, that the farmer must provide the occupiers with all the relevant documentation regarding how much the farmer has spent in developing or digging, maintaining of the farm's borehole. The report was ignored, and the Commission had to approach a court of law. We were told by the Honorable Court that there is a hierarchy of the Chapter 9 institutions based on how they appear in the Constitution. As you will know that the Constitution starts with the Public Protector and comes the South African Human Rights Commission. The judge interpreted that by saying this hierarchy suggests that the Human Rights Commission cannot have a power to make binding directives. We were told that the Commission cannot make binding directives because the Commission does not have coercive power, it has cooperative power. The court also said that the directive to the farmer to refrain from interfering with the occupier's access to water was not binding, but that the directive to the farmer to have a consultative session and to provide the relevant financial information is binding. You need not to be a legal expert to know this contradiction. This is part of the challenge that the Commission faces in respect of its work, especially its investigative reports. If this judicial approach to the powers of the Human Rights Commission is confirmed by the Supreme Court of Appeal and or the Constitutional Court, this will pose financial and human resource challenge for the Commission. In respect of finance and human resources, the Commission does not have enough of those resources in order to approach a court every single time a report has been ignored or every time there has been a violation. These judgments have the effect that the Commission has now to approach a court every single time. Truth be told, though the Commission does not have the human and financial resources to do this. The question and or challenge that we have for all of you in this room is the following. How can government departments, academics, and civil society organizations assist the Commission to ensure that its directives are complied with, and if there has been no compliance, that a court is approached to ensure compliance? An example is the following. The Human Rights Commission back in 2015 issued a report on access to emergency medical services in the Eastern Cape. During that hearing, there were many NGOs and activists and lawyers in a situation like, what is the role of the NGOs, activists, academics, when that report is not being complied with? During this conference, and ladies and gentlemen thereafter, we would like to form partnerships with all of you so that when we issue a report, it can be supported by all of you. When an NGO here like Difunukwazi or any other one litigates or advocates for the protection of a right, we would like to contact the Commission, that you contact it, so that we can support initiatives aimed at protecting the Constitution. In other words, let us join hands. I would like for state departments and other Chapter 9 institutions to work with us in ensuring that reports of Chapter 9 institutions are not ignored. Thank you very much.
Thank you very much for that input, Commissioner Simayone. The acting public protector reminded me that I should perhaps crack the whip a bit as the moderator and just remind everyone that this is an hour session until 4 o'clock. And at this point in time, we'll have to try and not exceed, let's say, more or less 8 minutes in terms of the presentations, please. So next is Dr. Dennis Matutoka. He is the Acting Chief Executive Officer of the Commission for Gender Equality. Thank you very much.
Good afternoon, commissioners and all protocol observed. Let me first make the declaration. I am not Dr. Matotoga, Dennis Matotoga, the acting CEO of the Commission for Gender Equality. I think the only common thing between the two of us is the titles. I am Tembingos Twalo, who is the head of the research department at the Commission for Gender Equality. My colleague and CEO, Dr. Matotoga, had a family emergency, so he had to quickly go to Polokwane to attend that. He had told me that he has sent, he had tendered his apology, and I just realized that for some reason the message did not arrive. So in my language they say "Ziyabotshwa noba zibhikile." So I guess I'll have to fill in the gap as I had just been requested. So this would not be a presentation. Actually, it would be the shortest chair of all these. My main participation at, or main interest at this conference was, in addition to being requested by the chairperson of the CGE to participate, but it was also informed by what we are currently doing in the research department. We've got 2 studies that we are currently engaging on. One is a study on women's access to communal land, and the other one is women's experiences in commercial farms. So I was more interested in gaining more and more knowledge that would feed into the 2 studies that we are doing that are related to this. There is, however, a report that I read by the World Economic Forum saying that gender equality, it is estimated that gender equality will be achieved in the next 131 years. That for me was frightening. And looking at the conversations that we're still having today with respect to land, I was frightened because it also means that it may take a similar time frame for land to be appropriately restored to its rightful owners. And this for me is rather frightening because there are implications for landlessness, your issues of poverty, an actual revolt by the residents, the citizens in the country. And it is something that I wish we can now move from the stage of discussing, having conferences, seminars, imbizos, and all those, and move on to implementation of all the decisions that have been taken in this regard, because this is a burning issue in the country, and the longer we delay it, the more serious the repercussions would be. I often compare this to the issue of buying property, for instance, as a person, that it is one of those decisions that you have to make as a person. And you can decide to make the decision early in your life and face the consequences. In my view, the consequences would be minimal if it's done early. You can decide to postpone the purchase of a property and decide to buy it when you are in your 40s or 50s, but still face the consequences. And I think at that time, the consequences would be more severe. So for me, this decision is a decision that should have long been acted upon, because the longer we delay the implementation, the more severe the consequences would be. And with respect to the Commission for Gender Equality, these are some of the things, these consequences are some of the things that we are witnessing on a regular basis in terms of the victimization of women, for instance, particularly in communal and traditional lands, because of customary practices that are continuing to deprive women of their rights to land and their rights to property in certain parts of the country. So shortly, that would be my input to say that I think it's time that we move away from the conferences, the seminars and all that, and move on to the implementation and ensure that we, as quickly as possible, restore the land to its rightful owners. Thank you.
Thank you very much, Doc Tembinkosi. And apologies for the mistake. I had the wrong information here on my paper. The acting public protector, Advocate Koleka Kaleka, indicated that she has to attend something else very soon and asked if she can be the next speaker, so we give her the opportunity. Thank you. Acting public protector.
Thank you. Thank you very much, program facilitator. I was actually excited when I heard Dr. Geraldine Muleketi speak, because it's some of the pointers I had. So I'm not going to speak on those, to also assist on the issue of time. And greetings to everyone. I align myself to the protocol already observed in the interest of time. While considering the topic, I came across some astonishing research and remarks, but I think most importantly is to look into the Sustainable Development Report, which has recently been issued, which actually confirms that the most challenges that we continue to go through as a country, it's unemployment, poverty. It in fact says deep poverty. So we cannot speak about those, and inequality as a result. So we cannot speak about those without really looking at the issue of land and what impact that has had to the current situation in our country. Now, South Africa remains one of the most unequal societies in the world by measure of disparities of wealth and income, living conditions, and access to education, health, and various other social services. Furthermore, severe race, class, gender, geographical, and other inequalities continue to be reproduced. Looking at the remarks by Michael Noble and Gemma Wright, whom in their paper titled Social Indicators Research, they observe that this inequality is unfortunately also characterized by strong racial disparities, which are rooted in our despicable history and legacy of land dispossession and the spatially skewed character of inequality in both our rural and urban areas. They also remark that, I quote, social policy scholars have mapped contemporary South Africa using multiple indices of deprivation, income, job, education, living conditions, health, life expectancy, and so on, revealing that the regions of the most extreme deprivation fit almost exactly the former boundaries of the Bantustans, I unquote. Many experts maintain the view that the large disparities in access of the poor and vulnerable to some of the essentials of life are, I quote, a constant and stubborn reminder of the unfinished business of our democratic project, I unquote, which amongst others must seek to reverse the legacy of colonialism, in my view, and also apartheid, land policy that continue to underpin rural residents' struggle for social reproduction, I unquote. This is a highly emotive issue when one considers the history that the devastating consequences of racially based dispossession and discrimination
against particularly black South African population. Now, our overcrowded reserves were the only area where black Africans could lawfully own land. For many black South Africans, forced removals meant that people were driven from their homes, loaded onto trucks and transported and be relocated in other areas. Now, I'm not going to deal with the exact figures and the laws. When I came in here, I think the panel then extensively dealt with those issues. But what is critical, I think, especially as a Chapter 9 institution, is to look whether with what is before us, the legal framework taken from the Constitution, has our democratic government thus far been able to address the imbalances of the past and have improved the lives of the people through the issue of land? Now, my answer, just out of my head, is that inadequately and close to none if you look at where we are and how far we have come. The keynote speaker spoke extensively on the legal framework before us and the policies before us, and whether has government adequately utilized those, at least to a maximum of what is required by the Constitution and through the national legislations that have been put in place. And the answer is a definite no. And there has been several programs, both the material and non-material indicators in this regard fit the disadvantaged category of land reform beneficiaries. This is because poor people being land restitution, looking at the land restitution program beneficiaries or not, are still excessively affected by discrimination, oppression, and other problems despite provisions made in the South African Bill of Rights. The land restitution program in South Africa and the different poverty claimants and beneficiaries of the land restitution program include some of the most marginalized people in society. These programs deal with a percentage of poor people who are vulnerable to have a lesser ability and skill to bargain with their own initiatives. The beneficiaries lack of power, and that makes them more vulnerable and unable to change their quality of life. Now, if you look whether as well has government effectively utilized conciliation, mediation in respect of this aspect, we feel that it has not been effectively utilized. But also, if you look into the legal framework, which I said I will not deal extensively on, but I really just want to touch briefly on the matter that the Constitutional Court decided on First National Bank of South Africa Ltd, WesBank versus Commissioner South African Reserve Revenue Service and another, where the court actually indicated that there are cases that may warrant expropriation without compensation in certain circumstances. Have we had a situation where our government has actually explored this particular case and said in which circumstances actually can they apply expropriation without compensation and be able to move from that angle? These issues regarding expropriation, deprivation, and compensation lead to the assessment and analysis of the Expropriation Act 1975, and the question whether the current formulation of Section 25 allows for expropriation without compensation. But I think the court in this Nedbank case then actually deals with this particular issue. Now, looking at the challenges and blockages, and I'm not going to shy away to deal with some of the realities that our country is going through, is the weaknesses, the institutional weaknesses in the policy choices that government seeks to take. And as the colleague from Human Rights Commission has correctly said, ignoring the recommendations from Chapter 9 institutions such as the Human Rights Commission. And of course, from our keynote speaker having dealt with other reports, it is very clear that there's quite a milestone through which government could have gone through, having taken advice which it had sought itself, it paid for, so it remains fruitless and wasteful expenditure, and it could have at least assisted government through putting in place some reformative measures. We tend to agree from the side of the PPSA with the view that traces the policy design weaknesses, poor implementation, and prolonged underperformance on the land reform program. We suggest a more fundamental dilemma, starting with the lack of a comprehensive vision of the kind of restructuring that is desired, the means by which it is to be carried out, and the intended beneficiaries, basically the structure through which this should be done. In the experience of the PPSA as an oversight body concerned with improper and prejudicial conduct in state affairs, the intended and unintended consequences of the policy decisions that are perceived as governance and administrative failures emanating from adverse or the weak implementation of these policies can often be traced back to the primary regulatory framework. And let alone the issues of corruption. I mean, there was an investigation that was done by the SIU from a period of 2011 to 2017. There was a lot of corruption that was picked up in implementing land reforms. So corruption has also been an impediment in the issue of addressing the land question, which also then weakens the developmental debate around the issue of the land question. But in any event, corruption in our country weakens a lot of debates in respect of addressing the imbalances of the past. Because if the conduct was proper, the intentions were in line with what the current provisions of the Constitution lay out, at least we would have gone a mile further than what we are. The report by the SIU actually looked at 145 farms, and there was a reason to believe that corruption had occurred. It found in numerous instances where beneficiaries who got farms were not entitled to those. Those who got farms to live on and work did not live there. And the price for the land was inflated by government officials and sellers, and weak systems and controls left the program wide open to abuse. In the case of bribery as well, public officials solicit money and private individuals offer to pay money in order to obtain privileges that they would otherwise not be entitled to. There's been several studies also done by Corruption Watch and other organizations. Now, these cases depict a national picture of rampant bribery, misappropriation, embezzlement, and theft of these resources that are supposed to go to those who've been at disadvantage. Though there is a synergy amongst all the focus areas with regards to the theme of land corruption, in the National Outlook, 60.6% of the reports of corruption received, for instance, by the study done by Corruption Watch, are about housing issues, while 24.3% and 15.1% relate to the land and mining sectors, respectively. The majority of reports of corruptions, 38.3% of the total, emanate from the Gauteng province, followed by KwaZulu-Natal, and then the Northwest, according to this study. Now, if you look into this, what then, how does it hinder government and both the people? The misallocation of resources, delayed implementation, lack of accountability, issues of land grabs and speculation, distorted priorities, ineffective implementation, erosion of trust, legal and administrative challenges, lack of investor confidence then happens. Now, the experience that we have as the public protector is that the matters that would come before us, normally it would be alleged that there's been a misuse of power by officials of the state institutions, as they would have been colluding with SAPS, for instance, to ensure that community members are either removed and others not removed, but also so that the tribal authority can proceed with illegal sale of community land. So the issues of the involvement of the tribal authority also becomes a matter that needs to be looked at. C alleges that the land restitution in 1998 and the government paid the compensation to the affected communities. However, the communities is taken by the government officials, the compensation rather, for their own benefit, and would further allege that the total amount paid by government for the benefit of the community would not be what is actually due to them. Irregularities in state institution regarding the portion of land which is allocated, for instance, to trusts for development, but that land was given to other companies without the trust's knowledge. There would further be allegations by of state institutions to resolve the land claim issue, since the complainant would have been told that the land was erroneously given to wrong beneficiaries, so it amounts to other beneficiaries receiving that land. And there would also be allegations of inadequate handling of the database in respect of this. Now, on whether Section 25 of the Constitution needs to be amended, I think this is a debate that the country has had extensively. I am not against the amendment of Section 25 of the Constitution, but I think we really need to sort out and align the current legislations and policies at our disposal and see what are the serious hindrances that are there, and how will the amendment of Section 25 of the Constitution address these hindrances, but also look into how will those amendments then be effected to the betterment and ensuring that there is equitable distribution of this land. But also, I think any legislation that we have, including the supreme law of the land, if corruption is at the center of our governance, we would not be able to implement what is intended or envisioned in our Constitution. Thank you.
Thank you very much, Acting Public Protector, for that rich contribution, and I'm sure we will also be able to get access to your speech, so that we can really make sure that we make use of some of the very interesting information you've conveyed to us in applying our minds further on the matter. Next, it will be Professor David Luka Mosoma, the Chairperson of the Commission for the Promotion and Protection of Cultural, Religious and Linguistic Communities. Thank you very much, Chairperson.
Thank you.
All the best.
Thank you so much. All protocol observed. Shakespeare wrote many years ago. I think what he said is still true today. He said the fault is not in the stars. The fault is in us. Similarly, Frantz Fanon wrote that each generation must, out of relative obscurity, discover its mission, fulfill or betray it. Since this morning, we've been discussing issues of land. And nobody ever attempted to demonstrate the source except to say 1913. I have come to discover that belief systems are very powerful. They make or break societies. And in the 1400s, there was a doctrine called the doctrine of discovery, which was drawn from the scriptures. And this doctrine propelled and created a framework for colonial dispossession of lands. because the claim, each land you occupy, it means it does not belong to anybody. Terra nullius. Now, we track our dispossession from 1913, and yet its source is biblical. And we are all members of denominations in it. And we don't realize the impact that the belief system has done in terms of our own dispossession. Maybe we need to look at that. It's critical. Second, it will help us not to have a lot of discussion, because the rest of the things that have been said today, we all know. But the issue is, what do we do? That's the challenge. Convene a meeting to identify 3 things which must be done and must be done effectively. From the CRL Commission, we are not directly linked with the issue of land, but we do appreciate its importance. For example, we appreciate what former President Thabo Mbeki said when he says, I owe my being to the hills and the valleys, the mountains and the glades, the rivers and the deserts, the trees and the flowers, the seas and ever-changing season that define the face of our native land. Very beautiful. It was in 1996. Now, our people, for whom we are responsible in terms of our own mandate, are cultural, religious, and linguistic communities. And these are the people who have suffered removals in many ways. Dispossession is part of their everyday life. Now, what do we do as a commission? As I say, we are responsible only for what we call social cohesion and nation building. But we cannot separate nation building from the land. Why? Because all activities which define who we are inextricably bound with the land. And so it is imperative that as CRL, we focus on some aspects of the land. And for this thing, for this reality to really come up clearly, is that we appreciate keenly that social cohesion or even peace cannot flourish in the context of landlessness and indignity. So there are challenges that we come up with, which we try to solve, for example. From the cultural perspective, people have had restrictions with regard to access to family graves, to perform rituals, because the inhibition has been their family graves are in farms. Now, always when black people get into farms, they are associated with the possibility or potential of claiming the land. So farm owners do not want to see black people going there to do rituals, because they say, well, they are going to use that as a basis to claim this farm. So we have had many instances of intervention where we agreed with the farmers that when people come, segment an area where they have to come and do their work. Why do we do this? We do this because the land is not in their hands. We try to find a way to make sure that at least we ease their burden. The issue of recycling of graves because of land hunger, for example, in Cape Town, in KZN, recycling of grave means after 10 years, they remove the body of the one buried in there and bring a new body there who may not be related to the persons whose that person was there before. So we try to find a way of trying to assist in trying to come in with bylaws so that there must be an easy way in which only a person related to the one who passed on must be buried on that grave. Not put somebody else. Because when you go and do your amasiko or your rituals, and you go there and try to communicate, you'll be communicating to a wrong spirit. So we are trying to say, don't do that. If this person is Dlamini, you remove the Dlamini body here. Bring Dlamini body there again in terms of the succession in their families. So these are the things that hurt our people. We have experienced in Cape Town, for example, land for initiations. People had to go to court. They refused to allow people to have the initiation in those pieces of land. So there's a real need that land be restored to the indigenous owners. We have challenges with regard to traditional health practitioners who use herbs and medicinal plants for their trade. However, because of lack of land, they have nowhere to go to get these medicinal plants. With regard to religious people, you have seen many congregants dying in rivers, and some of them worship in streets and they worship in fields, and they have no possibility of getting pieces of land to build their churches. But then, of course, we have bylaws in which we have spoken or communicated to the municipalities so that whenever there's a new planning, residential planning or settlement planning, they must include places of worship for indigenous, for religious people. So these are some of the challenges that we have as a commission. Of course, majority of the things that we do is that we get settlement with those that we deal with. For example, in the Midupi State Power Station, there were many graves on which they wanted to build Midupi Power Station. We had to go there and then get into some negotiations. So they removed the bodies into a special area, and then of course all the functions and the payments were done by Midupi, so that they should not build infrastructure on the graves of indigenous people. So these are some of the things that we do. Of course, we want also places that are used for rituals and worship, like caves, to be protected. And we will be sort of releasing a report next month about sacred places. Many of you may not know, but we want to share with you that there are sacred places where people go there and find healing in trying to communicate with their ancestors and things like that. So our responsibility really, it's about social cohesion, peacemaking, humanity, tolerance, unity on the basis of equality and the free association. These are the things that we deal with. Resuscitation of the indigenous systems that may have been eroded in the past throughout the colonialism, to bring them again in terms of language, in terms of rituals and things like that. But we have also realized that in order to make sure that the restoration of land really succeeds, it is important prior to the allocation or restoration of land that training should take place. I'm saying this because I am also one of the beneficiaries in my own communities. Pieces of land were given, but these individuals, I can tell you, they were not trained. And some of the things went wrong as a result of that. So we need that prior, if you have maybe 2 years to restore that land, make sure that the community is prepared. So that whenever you restore the land, the community can take over and use the land productively. Thank you so much.
Thank you very much, Chairperson, for those valuable insights from your side. All of this really contribute to a very valuable discussion that we're having. So, last but not least, I am going to ask Ms. Gabo Kumape. She is the business executive responsible for the entire rural development audit portfolio and Education and Labour at the Auditor General's office. So thank you very much for being here.
All right. Good afternoon, Program Director. Protocol observed, all colleagues across different sectors of government. Allow me not to dwell into the findings and the observations. I think they've been alluded to in a greater length. But there's just few things I would like to touch on. And by the way, please receive greetings from AG Sakane Maluleke. Just a highlight of what we do and what we cover and where we believe we could help one another in just making sure that the issue of land restoration become a reality, similar to all other aspirations of government. So by law, we are responsible to provide an independent view of how the government funds were utilized, right? And I want to emphasize that because ordinarily when the Auditor General comes out and say, look, these financial statements, in my view, they are reliable, you are able to make decisions based on these figures that are sitting here. There's also a correlation with regard to the performance report, right? So there's a great work that we do with regard to the annual performance plan, and allow me to remind you that that which is not planned for will not happen. So where am I going with this is that the conversations that we are having, they must find expression in the plans of government. If you look at government plans, if you go to rural development or look at their APP and the strategic document, and you do not find, to a larger extent, that which you conversed with them about, it is not going to happen. And it's important for us as the AGSA to highlight this, because by the time the Auditor General comes and say, look, this is where the money went, we are informing you that the money went where it was planned. The question is, that which was not planned for, what happens to it? I think the Commissioner earlier on went at great length in highlighting, the limitations, the budget constraints. And it's important for us to pay attention to that, so that we say, in that limited fiscus that you are sitting with, to what extent are you going to make sure that the land processes get completed, to the extent that my wishes have been expressed? I just hope that I make sense. And I say it because as the Office of the Auditor General, we are always confronted with, AG, your opinion and what we are seeing on the ground, there's no correlation. And we're trying to say, please pay attention to what we would have said. Even if we say the financial statements present in all material respects, we're basically telling you that they are transparent in what they've done. But the question is, did they do what you had hoped that they do? And that's where we need to pick it up. And as part of our strategy, so we just launched a new strategy in the office. We call it a culture shift, because our aspiration is to make sure that the public sector culture changes to that promote the interest of the citizen. So we are a member of the independent Auditor General around the world. South Africa is responsible for the capacity building. We drive that. And in there's a particular standard, and it's called P12. And in P12, it was nudging the Auditor Generals around the world to pay particular attention to the matters that are of essence to the citizens. And land is one of them for us. So yes, we did a lot of work on a program 3 of the department that will include food security. We did a lot of work on the land and restitution. But we are asking you to please just pay attention to our report when we table it eventually. So we're going to take out a general report around November, and we'll allude to the coverage and what we had found. Majority of them have already been covered, and I'm quite comfortable with some of the things that the department itself already presented, because I think there's transparency that coming through. In 2018, we had a lot of debates with the department because we were advocating for the commission to be independently reported. It was a big deal for us. Why? Because we knew that the issues of land will be swallowed if they are left within the financial statements of a department. So 1920, the department listened to us and they brought it forward. So right now you are able to see diligently the financial reporting of the Commission on Restitution. The question is, what does it tell you? And does it align to what you've been promised? If not, what are we doing about it? And I think it's important that we make sure that we also consistent in following the department up. And I think earlier on there was a conversation of, can the civil societies, can you be there when some of these things are happening? Because the work that the Auditor General does is literally to promote transparency. But once I put transparency on the table, I am relying on other stakeholders to come through. Yes, we had an amendment of the Public Audit Act that had given us a mandate to enforce where there has been a fiscus loss. And that's exactly that. This is where you are actually bleeding money unnecessarily. But if the money has been utilized according to the plans, there isn't so much of an issue. But it may not necessarily mean that the aspirations of the citizens have been completely attended to. And that's why we need to make sure that we are there when these plans get approved. That we say, where is my conversation that I had with you in this particular platform? Show me. And therefore you rely on the Auditor General to come through with the feedback in terms of the utilization. In our view, as the Auditor General, we say that for us to really have a proper sustainable improvement as South Africans, there has to be a strong element of accountability. And here is my humble submission. Part of our strategy right now, we had to relook at how we audit. And we had to say to ourselves, beyond auditing the Commission on Restitution, the Department of Rural Development as an example, individually together with its entities, to what extent can we connect what they do to other role players? But when we work on that journey, we are dependent on many of you to actually also dot some sort of an ecosystem. And I guess our submission to your human rights is that you're already best placed. This is a good conversation. Is it possible for us to dot who's supposed to do what? So that on an annual basis, when each and every entity of government is giving feedback, I go back to my ecosystem and I say, which loop are you closing? If you're not closing a loop in this ecosystem, then we are not assisting each other. It will make it a bit easier for us, but importantly to make sure that as much as we may not sprint, we will make progress that is sustainable, that we are able to build on it. I guess what we are asking is, can all entities of government and all, including the CSOs, because you remember that the CSOs come through in terms of the areas that are of great interest for the citizens. But once we closed these areas, in terms of who must respond, we ought to have that ecosystem. Then the Auditor General will be able to complement you. Because when we complement you, we know that when we deal with the issue of Section 25 of the Constitution, in this particular entity, this is what we're looking for. In this particular entity, this is what we're looking for. Because right now, we also see instances where, yes, the land had been given back where it belonged, but the facilities are not there. The local government had not come on board to make sure that the services are running and therefore make that particular area more usable and more productive for what it was intended for. So I guess the Commission of Human Rights, our submission is just, can we work on an ecosystem that we are able to dot the role players, that we are able to say, these are the things that we are expecting as we progress on a year by year, and we are able to hold each other accountable. We would also organize our audit team in making sure that when we look at the issues of land, we're not only looking at the Department of Rural Development. We ask ourselves, where is water and sanitation in terms of the rights, the water rights? And where is the municipality and COCTA in making sure that they close the loop on what's supposed to be there, and ESCOM and all other role players. One other thing that we need to work on, that we believe that it can take government a long way, just leverage on government data. A lot of the work that we do not get data anywhere else except in government. But we find that we are not necessarily interlinked. We are not networked in a manner that makes it easier to say, if this person is claiming the land for this particular family, and this particular identity numbers, can I corroborate this in the Home Affairs? And you don't rely on copies of IDs that comes through. And it just makes it a bit easier. It makes government more efficient. And importantly, it alleviates pressure on the citizens that are trying to find assistance from government. So from our perspective, we actually think that unless government, as government, we change the culture and we prioritize impact, it's unlikely that we're going to get somewhere. And by this, I'm suggesting that the annual performance plan of the department, of all other role players, they must speak to the impact we want to see, not just the effort we want to put in. It's one thing to say, I'm going to put 6 million in. But you ought to be saying, what do you want to see with that 6 million coming out? Because once you measure the impact, you are able to determine where these issues of market values and are actually not necessarily in the interest of the citizens. I guess our pledge to continue supporting government, we continue to relook at our processes. You will see for the first time when we release the general report this year that beyond reporting on individual entities, we'll have the themes coming through. And we'll be able to see some of the conversation that we'll have on the land issue as well. Like I said, I will not go to what we find in terms of the audit, right? I think some of these things have already been alluded to. But please be reminded of the preamble of the Constitution. As a stakeholder, that we said as the people of South Africa, we recognize the injustice of our past, we will honor those who suffered for the justice and freedom of land. If we take that to heart in our roles, we will endeavor to reach out to each other and make sure that we close the loop so that the citizens feel one output. And that output will mean that the Chapter 9s are networked, but importantly it will mean that the entities of government are networked. Our observations we share with the entities, we shared with the department already. We are in the process of making sure, like I said, that we'll table the rest of the report for the public consumption and we'll take the conversation forward. May I leave it here, Program Director? Thank you.
Thank you very much, Ms. Kumape. That was Thank you very much, Ms. Kumape. That was quite an input. And Commissioner Simayone, I hope you heard that she indicated maybe sitting together with the Auditor General and then mapping out the roles and responsibilities to get things done. So she's given the Human Rights Commissioner a very important task here to consider, and a new task. So let's see how we can take it forward. We have actually exhausted our hour for this discussion, but let me ask if there are specific inputs or questions from the floor, and let's take a few of them. And please direct your question or input, if you have one, directly to one of the participants. Any hands? Please go ahead. Maybe let me just first see, can everyone just put up their hand, those who want to, so that's number 1. Is there number 2 there at the back? I don't see anyone on this side. Doesn't appear so, so it seems there's one question. Please go ahead.
Since everybody's this side, I thought let me just bring the mic.
Good afternoon, everybody. I am Chief Lungalo Nokwaza. I'm part of the Condoleezza delegation. I think it has been said to say more than once that the initiative you seen by the Commission's rights is actually most welcomed. Also, the inputs you seen and then by various experts, I think they are most welcomed. However, we have to actually start by saying, as much as they are most welcomed, but the issue of the transfer of land to its rightful owners is an ongoing concern. It's a very unfortunate ongoing concern. Almost 29 years, almost 30 years after the 1994 democratic breakthrough, we were still talking about the land which has not been actually transferred with rightful owners. And in terms of the inputs and also the input from the government, and then official, the DDG, yeah, there was a DDG in one section, it was quite clear that the government is not doing what it's supposed to be doing in terms of ensuring that transformation happens in a meaningful manner in our country, in a manner which changes the people's lives, in a manner which improves the quality of life, and then from Gajane to Limbombo. And that is not happening. I'm not trying to be negative, but it's just that I'm talking in terms of daily experiences of our people on the ground, including myself. I think something has to be done, and then something meaningful has to be done. Other than that, we will be sitting again, 20 years again, even the generations to come, they will be sitting again, and then saying the very same thing, which we all know, which have been said, and then since 1994. Well, lastly, very lastly, the section 25 is actually said that, I think most speakers, they are saying that it has to be reimagined. Well, but then we definitely have to go on the same page as to what do we really mean by that. We can only and only ensure that that section, and then gives the impact it's supposed to if we're on the same page in terms of what do we mean when we say it has to be reimagined. Because I also one of the people who agree that that has not been tested fully, that clause. Instead, we actually jumped, the ruling government, or the government jumped for amendment without having tested that clause fully. I think that should be a starting point, because it's not all bad as it is, and then. But I should think you just have to be quite serious now, and then. Otherwise, on the ground, our people are suffering, and it means these gatherings, as much as they add value, but if they cannot transform people's lives, they amount to nothing.
Thank you. Please go ahead. Thank you very much.
Thank you very much. My name is Khoshi Malikan from Limpopo, in particular Sekhukhune land. I'm a practicing senior traditional leader. Chair, from Contralesa, let's thank the Commission for extending this invitation to us. From this morning, the panelists gave us very useful information, and we're grateful for that. However, there are two questions which I need to raise. We're given information that 72% of land in South Africa is owned by the whites, that 15% by the Coloureds, 5% by the Indians, and 4% by the blacks. Now, we're not informed what percentage is owned by the foreigners. We want to know. People who are not South Africans, yet they own land in South Africa. The second issue, Chair, is we have had various meetings with government. I think the last meeting was in this very venue where we're sitting with our president. And as Contralesa, our argument was that what is wrong in government transferring ownership of the 13% that is occupied by black South Africa, particularly in communal areas? And we believe there's no need for budget for those because it's government owned. And we're saying transfer it immediately into title hold. And we're wondering what is delaying government in doing that. So having said that, Chairperson, it is very disturbing because apart from the 13%, there's also land that belongs to government. And we don't believe there's money needed because it belongs to government in any way. Money will be needed to buy private owned land. So if government can prioritize this, some of us will be very much happy. Secondly, there is about 32 farms, Chairperson, in Limpopo, which have been bought by the Bapedi. these 32 farms are being kept by government, the Minister of Land Affairs and Land Reform. And we've been battling to get those title deeds transferred to the Bapedi Nation. Now, finally, having listened to all the inputs that have been made, if I were to make a summary of the input, it means our government is not listening. Government is guilty. Now, I'm asking the lawyers who are in this room. There is an instrument which is used by lawyers. When an institution is not fulfilling its constitutional duty, I've forgotten the name of because I'm not a lawyer, but there is an instrument which government must use to force this government to perform in terms of what it's supposed to do. Because from where I'm sitting, chairperson, our government is guilty for human rights violation. Now, what do we do? Give us the road, give us the way, give us the advice. We'll take government to court. Thank you very much.
Thank you so much. Is that the last question, or was there another one somewhere?
Yeah, no, thank you.
Yes.
I
Oh, yes, you were the
thank
first.
You. Thank you very much. Yeah. No, good afternoon to everyone, and good afternoon to the panel, and thank you for the wonderful inputs. I'll speak more tomorrow because I'm in the program, but I just want to ask a key question. All the panelists are people who have authority in the country, actually represent very powerful institutions. And I think your combined authority can actually help us to move forward. What is glaring, though, in your presentation is that not a single one of you has said how you're going to help us as people to get back our land. You have instead given us an analysis. I appreciate the fact that the Human Rights Commission has convened this meeting. Perhaps we can help you if you have not yet thought of how you can help us as a people to get back our land. For a long period of time, institutions of state work in silos. Maybe the reason why you decided to sit in that fashion as authorities and leave us this side is to actually for you to combine your intention, your intellect, your authority, so that you can work in unison to help your people to move away from suffering. So I'm going to ask now a question, and I want to speak in my African language when I ask this question. Nizawubuyisana nomhlaba wethu. Cela nje nisixelele lonto nisinike ixesha eningabe nicwangcise uba nisibuyisele wona ngalo. Enkosi kakhulu.
Enkosi kakhulu. I don't see any further hands. Right, so what I think we'll do, panelists, you got the questions. Those of you who want to react to some of the issues can do so. Otherwise, we will also obviously take on board what has been said and some of them inputs being made, in terms of the report that we produce here following this conference. But I think the point that's been made very clearly is, for too long, there's been reports, there's been recommendations, there's been all kinds of things, but not really action. Even, the high-level report from government itself did not really lead to action. So I think there is an urge that we need to come up with a combined strategy. And maybe the matrix that the Auditor General was talking about is the way ahead, to identify what is the role of every single role player with a lot of constitutional power, and then to see what needs to be done, and that we follow up and monitor in terms of those role players really each and every one exercising the duty and the power that they should to make this process going forward. But that will hopefully be captured also in a report. But I give the opportunity now to every one of the panelists, if they want to just come forward and answer to some of these issues. Prof, you want to start?
Let me just respond to the when are you giving us the land, our land? As Chapter 9 institutions, we have awakened to that question. Just a month ago, if I'm not mistaken, we had our first meeting as Chapter 9 institution to assess our different mandates and how to combine our mandates to create substantial impact in terms of bringing about the necessary transformation. So tomorrow, on Friday, we are meeting to assess that. But we cannot answer today, but incrementally, the land is coming back. Thank you.
Thank you very much, Prof. Wonderful to have one of the leaders of our Chapter 9 institutions here to speak to that. Auditor General?
Without really re-emphasizing what I highlighted, right? I would have loved to put the department on spot and say, can they answer this question? They would know better. They should know better. But in our view, as I highlighted earlier, until such time that each of us take a piece of responsibility that the legislation had put on us, and we are intentional about directing it, it's unlikely. You are going to run from one institution to the other. We will also rotate in giving reports. You will not have a consolidated, comprehensive, integrated feedback on what actually is transpiring in government. And again, I'll reiterate my input. Thank you.
Thank you, Chair. I think it's important for us to collaborate, as the other colleagues have said, but what is critical, especially when it comes to our mandate, we are an oversight institution. So what we need to do, and which Contralesa can greatly help us with really, is what is supposed to be there, what has been there, what, in line with our mandate, what is the discrepancy between those, and how do we ensure that we remedy that particular discrepancy. But also looking at the reports of the Human Rights Commission, what is relevant and what is outstanding. And I think we've collaborated in this effect before on other matters, because our remedial action as the Office of the Public Protector is actually binding. And where there is no implementation of the remedial action, then there should be a judicial review. And we've also effected now to our legislation, which we are hoping that it's the first thing that the next administration is going to deal with, where it criminalizes the non-implementation of our remedial actions. So I think we really need to look at the strengths that we have as different institutions and say, how do we as oversight institutions then exercise oversight in respect of our different mandates. But I think we've had the conversation with the Human Rights Commission before, for instance, with regards to the report on education, and on how do we then work on that and make it and update it and ensure that it becomes a report with binding remedial actions, whilst we are dealing with the other issues regarding the powers of the Human Rights Commission. Thank you.
Thank you very much, Program Director. Without deviating from the responses by our sisters organizations here, I would like to say early today, the figures were given, how many percentage is owned by white people, how many by the coloreds, and how many by the Indians, and lastly, by the Africans. We must remember that legislation was used in dispossessing land. And I want to quote a portion of the preamble of the Constitution. And that portion says, and I quote, "We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to," then comes the core portion of it, "heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights." it is in the hands of the organs of state, the freely elected representatives that are given the power to heal the divisions of the past. And some of those divisions of the past is the question of land. And talking about land, it also talks to the establishing the dignity of the people, because without land, you do not have dignity. In conclusion, there are songs which says, "Ubuhle bendoda zinkomo zayo." I want to follow the chief here who has also stated in isiZulu. And the freely elected representatives, I think you will recall, one time in the National Assembly, they started singing, "Mabawulethe, mabalethe umhlaba wethu, sikhalela izwe lethu." They are the people who should not be crying. They are the people who have been given the mandate because they are freely elected to come up with the restoration of land, the redistribution of land, and the transformation of land. Thank you very much.
Any input? Thank you very much, everyone. That brings this session to an end. We really appreciate the participation of these distinguished panelists, but as you also pointed out, people who are really sitting in positions of organizations that yields a lot of power, and I think the time has come now to really combine all this power to move efficiently and effectively towards resolving this situation. And by the way, Acting Public Protector, the Human Rights Commission, is definitely also intending, as Commissioner Simeone pointed out, to appeal. We are appealing because we also do remain of the view that, as is the case with the Public Protector, the findings and directives and so on of the Commission is binding, and we think it is essential towards the realization and protection of rights in South Africa. Thanks to each and every one of you. Good afternoon also to my chairperson in that I see, Commissioner Majola, and the CEO there, CEO Makize. But thanks for everyone that have been here. Oh yes, sorry, I'm actually not the one who is closing. And with the presents, apologies.
Let us not deprive our presenters their rights to receive their gifts. Ladies and gentlemen, we have now come to the end of our program, but before we close, we understand that we took some time off the schedules of very busy individuals who are leading high institutions of authority. And we would like to say thank you very much for allocating us your time, and also taking into account that, you know, you are members of Chapter 9 institutions who are here to serve your communities. You have diligently done so by being here today with us until so late. So we would like to call all members of the panelists who were here in the morning, because during that time we were pressed for time and we had to hurry through the program and we were not able to do the ceremony. So we'd like to call them up so that they can also be part of those who will be receiving their gifts. So if we still have any members, can you come up to the front? Okay. All right. Over to you, Joyce. This is your part. Oh, the Commissioner. All right, over to you, Commissioner.
We can go, right? We can go, right?
Thank you very much. Let me just say, there are no strings attached.
Hey, otherwise I must declare.
Thank you, Doctor. Thank you.
Thank you so much. Thank you.
Thank you very much. Yes, I won't forget your name. Action is needed. Thank you so much. One woman, one hectare.
One woman, 1 hectare.
Yes. Thank you, Auditor General.
Unless they give us a clean audit. What clean audit? Thank you so much.
Colleagues, we have now come to the end of our program. There are very key takeaways that we need to actually think about when we go back to our institutions, although tomorrow we'll still be here. But just to remind us of what had been spoken about today in this reflection of the 110 years that we're coming from when it comes to the Native Land Act, is that our three panelists, just to summarize, is that they provided us with many insights into the status of land tenure and land rights from a political activism perspective through the civil society organizations who had presented here in the morning, who actually work with marginalized urban and rural communities. They made contributions in terms of what we should be thinking about when we talk about Section 25 of the Constitution. They also reminded us of how land reforms form part of the cultural and ancestral identities that are linked to traditional customs and practices. And the United Nations Human Rights Commission also made this emphasis as much as the last panelist spoke about this. We also looked into the land ownership patterns and institutional capabilities in implementation of land reform, land restitution, and expropriation. There's a lot to think about there when it comes to the way in which we have implemented the current legislative framework, the gains and non-gains that we have made due to these institutional capability weaknesses. We also looked at the complexities of land claims within the current legislative framework, which are not as clear as we thought they could be, but taking into account that we are looking for a way or a resolution to find ways in which we can mediate this lack of clarity. There's a lot of discussion to be had there. And also the gendered dimensions and disparities concerning women and land tenure ownership that are obviously embedded in our historical land dispossession that was engineered by the colonial and apartheid state. But the problem is that when it comes to women, the state tended to infantilize women, depriving them of the socio-economic autonomy when it comes to land. Lastly, we looked at how corruption corroded land reform programs through land grabs, elite accumulation and misappropriation of trusts. And also there was a reflection of the way in which we have been operating at this as a state, where we have to start thinking about complementary auditing ecosystems of state institutions, where we are able to bridge the gap between financial audits and social audits, because once we do this, we are able to look at the way in which land has been utilized, the infrastructure has been laid, and the way in which that infrastructure is supposed to serve those beneficiaries, which requires a much more integrated approach in assessing the impact that we are making. And this impact will help us to even understand the value for money that we have gotten out of the land tenure system, and also exercise accountability when it comes to land reform. So on that note, I hope I have been able to summarize some of the important issues that we will need to take with us, as we will need to provide recommendations tomorrow as a way of moving forward. On that note, ladies and gentlemen, tomorrow we will have our first commission starting at 9 o'clock. Fortunately, our traditional authorities are already here, and we are starting with them. They'll be giving us their insights and their experiences coming from those communities that they represent in rural areas. And most probably they'll make some contributions as well as moving forward with Section 25. And then another commission that we will have will be looking at the civil society organizations who have played a key role in land governance and administration and advocacy work that they have done throughout the years, and seeing how we can forge and strengthen these relationships. So let's see each other tomorrow at 9 o'clock sharp, and we will make sure that we will end the day quite quickly if we start early. On my side, thank you very much. I will see you tomorrow morning.